Sir, is there? Yes, Mr.
And I have been trying.
Please wait.
I beg apology. I mentioned yes, last week that I was not present during the time of hearing. So I mentioned that I may be excused for filing the written note of submission. That is what I am submitting here, madam.
It is too voluminous.
Beg your pardon?
That is too voluminous.
Manners, here I am fitted with state as well as the center. So naturally, this has to be voluminous. Manners. And there are two lead matters matters. So in both the matters matters, I have challenged the circular that your lordship must have come across. So I am giving the citation also. I am giving this matters. Sorry.
Please give that.
Yes, ma'am. And also the citations. Yes.
Yes.
Citations with regard to two parts I have divided. One is
All right. We are not
subordinate
hearing.
legislation
We will-
cannot make any subordinate authority.
All right.
Well,
All right. Yes. Please give your steps.
well,
I
may-
see that I have been trying since July.
Algar.
Get it registered.
Please give your slips.
That is the PIL matter, or after looking at the some purchase. In the written note of submission and list of dates for the matter that was heard on 19th.
Which matter?
The four matters that were attached together with regards to extension and challenging the demand on 19th.
There was a tender matter given this.
Again,
Attorney Lordship Board, madam. I think 36. I think 36. This matter was over for, we had argued that matter was closed for judgment, I suppose.
36 is what?
Admission matter that medical seat. Defense student of.
It has been
It was closed matters probably.
closed.
I'm wondering why. It is not.
All right. It will come
Item number 39.
after for judgment.
Item number 39. So last week only we have appeared for the opposite parties. So
Let it be taken up first.
So I have taken consent of the other side. I'll file my counter affidavit. Your lordship may call it on 9th.
All right. I'll jointly request it.
Seven, your lordships, that's fixed for 2 PM. Your lordship, I am very awkwardly placed, it's a personal appearance also. Your lordships, and otherwise also, actually I've sought.
No. This is what? 7 is what?
Seven is
that approval of the governing body,
college
introduction
matter.
of challenge, approval of the governing body of.
Who has been directed to be personally present?
No, it's not that matter. What I'm trying to say is, your lordship, I'm awkwardly placed today. If your lordships can adjust this matter to 28. I'm taking consent of senior Mr. Rath and also the government, your lordship.
No, Lord,
The 3 councils.
All right. Let the matter be called. I'll
Your lordships, no,
just ask for junior to be here.
lordships.
Give your slip.
Two ideas, your lordship. One for the implementation of new option purchaser and another for the lifting of the iron body, your lordship. Matter is already pending and the new option purchaser is trying to lift the iron body. So,
is there any particular date fixed?
earlier there is a notice has been issued.
But no date.
Moreover,
You've written the reason. Have you written all the reasons in your memo?
your lordship.
That will be seen by sir.
Orders. Matters under the heading for orders, item number 12.
Here there is a delay of 76 days. The issue involved is whether the period of service with the job contract establishment is a qualifying service under the Orissa's OCS pension rules 1994.
I think 12 and 17 are similar.
Same point.
Similar order, my lord.
Item 71, I have appeared on behalf of one of the respondents.
Item?
17, approximately.
Yes, you have appeared and Mr. Mahapatra has also.
My lord, a copy may be supplied, so we read it in a moment. But so only limited to recognize me.
Let the delay be controlled then. Have you checked the order in Yudhishthira Padhi? Is it your matter?
Yes, my lord.
Have you checked the cause list?
Yes, my
Notice
lord.
is not sufficient and one person is supposed to be dead.
Yes.
You are appearing for
Respondent one.
respondent one.
My
Yes.
7.
And Mr. Meher?
respondent 10, number देना कि 10 बोली लिखा है, 210 बोली लिखा है जी. Because I have got no appeal memo, unable to know it. Clear me.
Item 17, the happens.
All right, first
10,
matter,
10 my lord. Respondent number.
first matter, there is a delay of 48 days.
Okay.
We are condoning.
Condone.
IA 1202 of 2023, full stop. This application has been filed for condemnation of delay of 76 days in filing the writ appeal. Concerning the period of delay, comma, the reason stated in the IA for the reason stated in the IA and in the interest of justice, we are inclined to condone the delay in filing the writ appeal. The IA is accordingly allowed and disposed of. Have you received a copy of the appeal, ma'am?
Not received, ma'am.
Madam, can you give it today just now?
Yes, my lord.
Ms. Aishwarya Das, learned additional standing counsel, hands over a copy of the,
In course of the day, my lord.
all right, or undertakes to serve a copy of the appeal memo on Mr. B.K. Mahapatra, learned counsel for the respondent in course of the day. List the case on. What is?
My lord, I have given an order, my lord, after batch of cases, my lord, pending SLP order.
The SLP pending.
SLP, my lord, see that, read
Another matter was there, we had kept it.
my lord, read
tomorrow. So that is-
Kali udaks, my lord.
Kali order. So एक कोटे दिन में रखी ताकि सब tag कर देगी, then we can keep together.
My lord.
This is the case, जो मैं fresh admission हो, you point out, we'll tag the cases. This is the case on 2/12/2024 for fresh admission. Full stop. 17, you have to take steps. Because I think one respondent is dead, another correct address.
And there are 2 respondents where the address is not served, notice is not served.
So can you do it within 1 week? I'll,
2 weeks.
no, I'm doing it so that the case can be tagged with the other case. You try, otherwise we'll keep another date. In the meanwhile, you try. Item 17, in the IA, you write, office, note of the registry indicates that notice on respondent number 2, respondent 6 and respondent 7 has returned unserved. Ms. Aishwarya Das, learned additional standing counsel, granted 1 week time to take steps, to take the further steps. This is the case on 25/11/2024. along with writ appeal number 482 of 2023. Let it be tagged and we'll see on the next. Acha, Mr. P.K. Mahapatra, learned counsel, has appeared on behalf of respondent number 1, and Mr. Tikera Meher, learned counsel, has appeared on behalf of respondent number 10. Sorry,
Second. Item 13.
So there is delay of 480 days, notice was issued, and tracking report says that notice was issued. Delay 480
This is the
days.
case on,
Notice is sufficient.
yes,
Delay of
I
480.
know, I've seen that.
Hello?
This is the case on 2/12/2024 along with the postal tracking report.
Item
No,
14.
sorry, postal tracking report is there.
Yeah.
Based on 2/12/2024, registry to verify in the meanwhile, if the council has appeared on behalf of the respondent, as the postal tracking report indicates that the notice has been served on respondent number 2. Yes,
Certified copy, I will go.
yes. 2381 of 2023. Mr. K.C. Kaur, learned government advocate, undertakes to file the certified copy of the MPN order within 1 week. I think the said submission, the IA is disposed of. Certified copy shall be filed within 1 week as undertaken.
Item 14.
Some fucking man of there has been a delay of 180 days. This is that case of rehabilitation estate, Model the city.
What is the defect?
Defect, my lord, it has already been removed. That's what the web report says, or the Honorable High Court says. All objections are complied on 15/5/2023.
Mr. Das, learned additional comment advocate, submit that all that defects pointed out by the stamp reporter have been removed. But the office note indicates that defect as per stamp reporter, as per the stamp reporter, have not been removed. We shall remove any defects, any subsisting defects, if any, in the meanwhile.
Yeah.
Since postal tracking report indicates that notice is sufficient, notice has been delivered on the addressee, list the case on 2/12/2024, along 2/12/2024, registry to ascertain if any counsel has appeared on behalf of the respondent.
Item 15.
Just a minute. Mr. 13 and 14, keep it to 9. All right?
Yes.
9.
9.
9. It will be easier to give them some time to appear. The dates may have been fixed in this week.
In item 15, my lord, there has been a delay of 121 days. Here the
Registry shows 96 days.
then my calculation must be wrong.
Yes, she's appeared.
Total period is 150 days, the 90 days of period and 21 days delay.
Yes.
120 days. That is the vehicle after contempt petition file, thereafter notice will issued, thereafter not complied that order. And thereafter appeal has been filed 10/5/2023. Order passed on 10/1/2023.
Right, only 121 days delay, that too by the state of Odisha.
As per Susama judgment value, the 100 days.
Include order is based on a judgment which has been stayed by your lordships in a writ appeal. Another writ appeal, that is 557 of 2022.
5/5.
2 of 557 of 2022.
We are condoning the delay.
5/5.
7, my lord.
557
7,
of
2022.
22, that is pending.
That is pending. In that
Date
case,
kya kya bachhe? Yes, that
in
case.
that case, the judgment which has been relied on by the honorable single
No,
judge has been
understood.
stayed.
Judgment reserved.
Has been reserved. 552, no?
Yes, ma'am.
All right.
557.
557, all right. IA 2681 of 2023. This IA has been filed for condoning the delay of 96 days in filing the writ appeal. Considering the Miss
PP.
Miss PP Rao. Miss PP Rao, learned counsel appearing on behalf of the respondent, submits that sufficient cause has not been shown for condoning the delay. Full stop. After hearing the learned counsel and perusing the application and in the interest of justice, we are satisfied that it is a fit case for condoning the delay in filing the writ appeal, but subject to payment of cost of rupees 2,000. The respondent within a period of 2 weeks. Within a period of 2 weeks. I is accordingly, the delay is condoned, the I is accordingly allowed and disposed of. Do you have a copy of the appeal memo? Not this copy of the appeal memo today or subsequently? Mr. Das, the additional government advocate, undertakes to serve a copy of the appeal memo. Will accounted for the respondent by tomorrow. List the case on 9/12/2024 for fresh admission. It is stated at the bar that WA WBC,
WA number 557 of
2022.
20.
the writ petition, that the order of the learned single judge which has been relied upon by in this matter, in this case, has been challenged in writ appeal number 557 of 2022, which has been heard and reserved for judgment by this court. This is the case on 16/12/2024. 19. 2 weeks have been- Okay. On 16/12/2024. Yes.
Item notes.
Writ appeal number 557 of 2022.
Item note 16.
Again, this is the case where the Morananda city's case has been relied on and without notice it has been disposed of 147 days.
Just a minute.
Your Lordship,
You are appearing. Very good.
I will appear in course of the day, Your Lordship.
Acha.
This is item number
16.
6.
Your name, please.
Mr. Niranjan Lekha.
Acha. No, upon
HK Mohta.
Mr. H.K. Mahanta, learned counsel submits that Mr. Niranjan Lenka, learned counsel and associates have instructions to appear on behalf of the appellant, on behalf of the respondent, and Wakalatnama on the behalf shall be filed in course of the day. Course of the day. List the case on 2/12/2024. Objection of if any to the IA for condemnation of delay shall be filed in the meanwhile.
Item 18.
Issued on 21/10/2024, my lord. For filing requisite, I have filed just the cyclone holiday was declared.
All right.
Thereafter, I have filed, but it was on.
So you have filed the requisites.
I have already filed.
Acha.
1 day delay is.
All right.
That is the
Notice for issue of notice. So this was in the main or in the IA?
IA.
IA Lakhondu 3082 of 2023. Since requisites for issue of notice have already been filed on 19/10/2024.
29.
Sorry,
29.
29/10/2024. The same are accepted. Full stop. Notice shall be issued as per the order dated, what was that order?
21/10/2000.
As per the order dated 21/10/2024, or say order returnable within 6 weeks.
Yes.
List the case after 6 weeks. Date?
13 January.
Yeah, so we can.
Item 19.
Delay of 90 days. Procedures.
I'm filing it. Objection to the limitation petition.
Why should notice go when it is already appeared and his name appears in the cause list also? To whom shall we issue notice?
So you are filing objection.
Yes,
We are condoning it.
yes, madam.
Delay we are condoning. 90 days. 90 days.
90 days.
They have not explained the delay properly. As per the judgment by law, decided by Chief Honorable Court.
All right, we are imposing cost.
ISP 3192 of 2023, there is a delay of 118 days pointed out by the staff reporter in filing this writ appeal. After hearing the learned counsel and perusing learned counsel, we are satisfied that this is a fit case for condoning the delay in filing the writ appeal. Justice, full stop. The delay is condoned, but subject to payment of cost of rupees 2,000 to the respondent within a period of 2 weeks. Do you have a copy of the appeal, ma'am?
No, copy of appeal they have not.
The IA is accordingly allowed and disposed of. WA. Mr. K.C. Corral, government advocate, undertakes to serve a copy of the appeal memo on Mr. R.K. Bisoi, learned counsel, on behalf of, who has appeared on behalf of the respondent, by
Tomorrow.
27/11/2024. List this case on 2/12/2024 for fresh admission. Yes,
Item not.
Taken into record.
sorry.
File it in the
Still what?
objection.
I have filed the objection that may be taken
Objects
up.
to the
Limitation.
ಯಾರಟಾರ ಜಂತೆ ಹೇಳಿಲ್ಲ objects PP Rao will be objection ಅಂತ ಲಿಖಿತದೆ. Take it on your word.
Item 20.
Taken on record.
Okay, item delay of 12 days, my lord. Notice has been sufficient. Postal tracking.
IA
Today I have
Back shot
filed
this is Kuriel.
on behalf of the opposite party respondent Miller. In course of that, I will file the Oakland number.
Your name, please.
I'll file the
Apna.
Sipo Prasad Swine.
Mr. Siva Prasad Swine, learned counsel submits that he has instructions to appear on behalf of the sole respondent and shall file wakalatnama in the registry in course of the day. Full stop. This is the case on 2/12/2024. Full stop. Objection if any shall be filed before the set date after serving copy on the learned counsel for the respondent.
21.
As per order dated 18/11, I have already completed, removed the defects to him. There's some delay.
21. 21 is for continuation of Writ. 88 days. Yes, it's not. Yes, madam, can we condone? Permitted.
No private parties.
No, ma'am.
IA number 4274 of 2023. This IA has been filed for condoning delay of 88 days in filing the writ appeal. Considering after hearing learned counsel for the parties, we are inclined to condone the delay. Full stop. The IA is condone the delay in filing the writ appeal. The IA is accordingly allowed and disposed of. Yes,
My lord.
Merit.
My- yes.
Merit, what do you have to say?
Any other than hearing.
List the case on 2/12/2024 for fresh admission.
Item 22.
Here, Mr. Biswal.
My lord.
Yes.
Item 22.
144 days.
So you are appearing for the OPSC?
For the Orissa Police.
All right. You filed your appearance memo?
Just today I'll file.
You
Today
will
I'll file
file.
memo.
All right. Mr. Arnav Behra, learned counsel, has appeared on behalf as submits that Mr. Arnav Behra appears on behalf of respondent number
1,
1. Can't be 1.
2.
On behalf of respondent number 2. Yes. How many days delay? We are condoning the delay. Any private parties?
No.
Considering the period of delay, no, this IA has been filed for it. IA ही appearance से भी लिख दो. This IA has been filed for condoning the delay of 145 days in filing the writ appeal. After hearing the learned counsel, we are satisfied that it is a fit case for condoning the delay in filing the writ appeal.
Appeal memo served.
You want to deposit some cost for the High Court Bar Association?
Yes, sir.
Who are you?
Private.
Sure.
Delay is condoned. The IA is accordingly allowed and disposed of. You have served a copy?
I have received the copy.
Yes. So, list of attention are here. Copies of the appeal memo have been served. Excuse me. On the learned counsel for the respondent. Hence, this appeal for fresh admission on 2/12/2024.
Item 23.
53, madam, the
Since
detail-
postal tracking report indicates that item has been delivered on the respondent, list the case on 9/12/2024. In the meanwhile, registry shall ascertain if any counsel has appeared on behalf of the respondent.
24.
delay of only 82 days, madam.
What is the issue?
He has already appeared for Mr. Truly and I served copy of the appeal memo, ma'am, by tomorrow.
You serve copy of the appeal memo. First, we have to condone the delay. Delay has not been condoned.
Condone, delay, that is what I'm saying, he has already appeared.
No, but why you saying appeal memo you'll serve unless before we condone the delay?
No, I am not.
What is the issue? What is the issue involved?
My lord,
What is the point involved?
point involved here is basically proceeding was done as a result of which the promotion to the branch of OS junior branch was withheld. That is the only reason.
Item 24.
Yes, ma'am. No, my lord, that is 19. Sorry, my lord, I have just.
All right, when counsel is not here, we can take up the matter tomorrow. Let him appear.
Rehabilitation appointment.
Although
All right.
Two more points.
I have you not filed the certified copy. Appeal of the year 2023.
We have already applied one required.
It will take 1 week.
We are applying online nowadays within.
No, nowadays means this has been filed in the year 2023. So you applied, you have applied for the certified copy when? Today?
No, not today. Last week we have applied.
Then you will get it. We are keeping it tomorrow. Mr. K.C. Kaur, learned additional government, unlearned government advocate submits that the certified copy shall be filed by tomorrow. Since learned counsel on behalf of the respondent is not present, list the case day after tomorrow. Yes, next.
Item 24.
All right, it will come tomorrow. Because of you, the matter is being adjourned. today.
I was late, so
What is the delay?
I was arguing.
Yes. Not delay in your appearance, delay in filing the writ appeal. What is the delay?
Delay. I am the respondent one. I am appearing for the respondent one.
So we are not seeking explanation from you. We just want from you what is the delay, whether we should condone the delay or not.
More than 282 days. 28 days of delay.
No, but again, the same Malayalam Sethi matter is there, no?
Yes, ma'am.
So let us condone the delay and consider it.
I pray not to me, but to in the bar, some cost may be imposed.
Oh.
Huge delay.
No, cost will go to your client.
Respondent. All right.
Cost will go to your client.
The state
Because finally he is suffering.
Mine.
So IA instead of tomorrow, give 1 week. All right. 7113 of 2023. This IA has been filed for condonation of delay of 282 days in filing the writ appeal. After hearing the learned counsel and perusing, after hearing the learned counsel, we are satisfied that it is a fit case for condoning the delay in the interest of justice. In the interest of justice, subject to payment of cost of rupees rupees 3,000 to the respondent within 1 week. List the case for fresh admission on 2/12/2024. So certified copy also we granted 1 week, you file it or list it on 9/12. You've received a copy of the appeal memo?
No.
Copy of the appeal memo that we served on Dr. Purushottam Chulli, learned counsel appearing on behalf of the respondent by 27/11/2024 as undertaken. Yes.
Item number 25.
As the note of the registry indicates that respondent 8 is the sole private party or private respondent? Why is the respondent number 8? Others are all state just a minute. Gram Panchayat 7 and 8. Okay. Since postal tracking report tracking report indicates that item has been delivered to respondent number 8. List the case on 9/12/2024. Registry to ascertain if any counsel has appeared on behalf of the respondents 7 and 8 and indicate the name and the cause title. Yes.
Item 26.
26. Certificate of defect and certificate of already filed by.
Where?
This matter, you
Which case certified copy already filed? Which case have you filed certified copy?
Certificate of the file in the improved OJH matter.
Which case?
Hello?
Which item?
26.
Which
Item 26, man.
This is for a stay.
So question of certified copy is not involved today. That has already been dealt with. Yes. No, not admission. Not admission. You have filed an IA for stay.
IA for stay, the matter without the sanction of the court, the book and attendant was appointed. So, but the department sanction because the one pure post was appointed sanction for the concerned school, my lord. But without having sanction for that post, the welfare officer of the district appointed the respondent as the post of.
So, what has the learned single judge directed?
My lord?
What is the order of the learned single judge? Why are you praying for stay?
Is there any urgency? We can take up.
Why?
Is there any contempt filing? Have you filed any contempt application?
Previously.
That has been disposed of.
Previously, there is
What is the direction?
no direction was there since the
No, what is
appeal
the-
was filed.
What is the direction in the writ order?
Order was passed on contempt. The contempt is still pending, and owing to the filing of WA that has been kept pending.
No, your disengagement order has been quashed. An order has been passed to take steps for absorbing you in the regular establishment within a period of 3 months.
Is taken by
So we can hear it. We can hear it today.
Yes, ma'am. Only point that he was calculating my lord, Chaudhary, I have appointed and I am appointed as an
All
attendant.
right, we will hear you.
You गलती से आज 25 will मतलब orders में list हुआ है. It is over. वो fresh admission लिखा नहीं था. Okay. List the case of fresh admission on 2/12/2024. The matter is listed for orders today. Full stop. List the case for fresh admission on 2/12/2024. Yes.
27.
53 days we have instruction
For
How many days?
respondent one.
Huh?
53 days delay.
53 is one.
53 days delay.
There is a
Months of delay. I had a logical we can give it.
private respondent. The problem is seven.
Who you are appearing for whom?
I am for the respondent of one contesting party.
Respondent number one. Who are the other respondents?
For 2 to 5.
2 to 5. Who is for 6?
I am for 6.
Mr. Patnaik has taken notice on R5 because of a typographical error in the order.
All right, everyone has appeared. We are condoning this. R6. Secretary, the Red Cross Society is appearing.
Society, they will engage.
Huh?
No. Do they have any counsel appearing in the High Court? I think they have some counsel. You find out, we'll.
Before fundamental, I will permitted to place one thing.
Oh.
Because he is a third party. And
Oh.
that means the person who has filed appeal.
So that is on merits, Mr. Counsel. That is on, we can dismiss the writ appeal.
That is the matter. And one thing, and that too, we had the region aside without any documents. They said they were dealing this month, nothing. And
Delay is
that too-
53 days.
53
Delay is
days.
53 days.
53
So
days.
you are a third party. You are not party in the writ proceeding.
Leave was granted on the last one.
Leave was granted.
And that
Leave
too-
was
and
granted.
most interestingly, one paragraph, it is appearance of the petition appellant that if the management of the school is handed over to the NGO, and that will petitioners, there is a respondent one, there is every likelihood of manipulation of records.
All right, we'll
I have
consider.
already annexed one document that has already been handed over.
All right, all
Now
right.
that has become
Yes, sir.
right now.
You serve on the council who usually appears on behalf of the Red Cross. All right. List the case on 27/11. Sorry?
No grievance against Red Cross.
Then delete that party.
Whether Red Cross was party in the writ proceeding or not.
Man, because he was managed, he was directed to manage the institution.
Yes, so necessary party if you are challenging the order.
Please inquire.
Then I'll take notice.
You'll take.
Or I'll solve copy of our card.
Mr. Subhasish Patnaik, Learned Counsel, undertakes to serve a copy of the appeal memo on the counsel who usually appears on behalf of Red Cross Society. What is the name? Red Cross, respondent number 6, bracketed Red Cross Society in the High Court. By tomorrow, list the case on 27/11/2024. Mr. D.K. Dilip Kumar Mahapatra, Learned Counsel, has appeared on behalf of the respondent number 1. Yes. You filed or you will file?
No, I already.
Here, you file it there.
Yes.
Mr. D.K. Mahapatra, Learned Counsel, submits that he has instructions to appear on behalf of the respondent number 1 and shall file with Wakalatnama in course of the date.
I also filed the objection.
Do it in the rest.
Item 28.
Because the super appeal memo
In course.
Serve it.
28.
Just one minute. This matter, I'll just check. Why this is. as the cause list on what was the last date of listing of the case, Mr. Agarwal?
11,
Sorry?
11th November.
As the noting in the cause list on 11/11/2024 was that ADs of notice issued to OP 1 and 2 had not yet been received, and the matter had been adjourned to today to be listed along with the postal tracking report, full stop. But today the office note indicates that notice has not been issued for deficit port fee.
Postal
Just
postal stamp of 15 rupees.
as there is a deficit of postal stamp worth ₹15 in the requisites, full stop. There appears to be some lapse by the registry in putting up the proper noting in the cause list on 11/11/2024. The registrar judicial is directed to look into this matter and issue appropriate instructions accordingly. Full stop. Next paragraph, Mr. Acharya, you are Mr. A. Agarwal.
Yes.
Full name, please.
Abhijit Agarwal.
Mr. Abhijit Agarwal, and the council submits. You have already filed it.
No, in the day's course.
Undertakes to file the postal deficit postal stamps in course of the day. Full stop. If the stamps are filed as undertaken, notice be issued to the how many respondents? Notice be issued to the respondents.
3 respondents.
2, I think. To the respondents by registered post, speed post with AD, as directed earlier, making it returnable within 4 weeks. This the case. 6 weeks.
13th January.
List the case on 13/11/2024. Yes. 13/1/2025. Yes.
Obliged.
Orders met over. Item number 3 to be taken. Item number 3.
Item number 3. Mr. Acharya, you are appearing in this case.
Yes, last occasion you not directed me to clarify on this issue.
Oh, yes, SCBC.
At SCBC. The difficulty in for the prospectus, the Odisha admission, because these are all state institutions. So we do not have any provision for reservation for the OBC, backward class, I believe. But we have provision for reservation for SCBC. The OBC list, my lord, in fact, is being prepared by the central government for the purpose of appointment in civil posts or other posts, and also, my lord, the central government purposes. But the SCBC list, which we have prepared, that is, my lord, maybe incidentally some of the castes are included in the OBC. And OBC list also, my lord, contains, my lord, the SCBC list, which is not there in OBC. So the state is, my lord, applying this SCBC list. So in fact, as per the Nursing Council guidelines, lord, they say that some concession is to be given so far the eligibility is concerned. That is not because Odisha doesn't have any policy of reservation. So far the admission,
Mr. Acharya, there is no controversy over the fact that you are not to follow, the state is not required to follow the central OBC list. This is for the central employment under the central government.
Absolutely.
Or admissions. So you don't have to follow that. You have to follow SEBC.
Absolutely correct.
All right.
Right.
So this SEBC is in fact OBC for a state of Odisha.
Your lordship is correct. No?
This
That is, my lord, your lordship is absolutely
SEBC is state of Odisha because the concept of OBC is the same.
Same. That is
Those who are backward classes based on caste, they are OBC. You call it SEBC or whatever.
Right.
If it is caste based, then it's your OBC. State's OBC. So if any you have to follow your own
reservation.
You are not required to follow
Correct.
the take decision on the basis of OBC list of the central government. So there is no doubt over this.
Absolutely. So that is exactly what the difficulty is. He is holding an OBC certificate.
Not he, them in number of.
In some of the cases. Yes. But this socially and educationally, we have two legislations. One is this reservation of posts and services. There the SCBC has been defined. Socially and educationally backward classes means backward classes.
Yes,
it is absolutely backward classes as defined in clause A of section 2 of the Orissa State Commission for Backward Classes Act. The legislation itself says it is for the backward classes. That has been defined. If your lordship would look at, I have given a compilation. Backward classes has been defined in the reference which has been made. I had given a compilation of the different legislations.
Can you do it?
Yes. Yes.
If I'm not mistaken, I had noticed a provision in that notification of yours that it also provides for admission in educational institutions.
No, we are not giving any concession in educational, but we will follow this. Nursing, I have discussed with the officers. So far, the admission, reservation in admission, educational institution, other things.
Yeah.
We have not yet provided.
Yeah.
But in services, we are providing 11.25%. Earlier, it was 27%. That the ceiling, upper ceiling, that was dropped down by the Honorable Court. So therefore, thereafter we reduced it to 11.25 so as to bring it within the permissible limit of maximum 50%. But so far the admission into educational institutions, other things are concerned. So far, Millard, there is no reservation policy.
You are not bound.
I am not bound. So therefore, Millard, so far the Nursing Council guideline is concerned. Since this is an all India body, and the students seeking admission into these nursing institutions, though Millard of the state institutions, they may be required to participate in other states in the national level also. So as a concession, your lordship may say, because on the last occasion there was a confusion. Your lordship quoted paragraph 8 of the policy, which says reservation as for the state policy. So the state policy gives this for ACBC, not in admission, but so far the appointment in the services and posts are concerned. Because the act which I referred to just now, that is with regard to the reservation of posts and services, 21st law 2008 Act. So they refer to this socially and educationally, not economically, socially and educationally backward classes. Backward classes has been defined in the State Commission for Backward Classes Act 1993. That has been defined like this. Backward classes for the purposes of this act means such backward classes of citizens other than the scheduled caste and the scheduled tribes as may be specified by the state government in the list. The list which I am just now referring to, that is the ACBC list, because both the things have to be read conjointly. So therefore, the list which is available with us, so far the reservation in the state services is concerned, that is the ACBC list. But my learned friend is, I think, holding the certificate of OBC. It is not interchangeable. SCBC. If that is SCBC also, we will provide. SCBC provided, that is, SCBC, we are providing. SCBC stroke OBC, you are right. But this is not a concession for next year, we will come out with the policy. But since the admission is upping, I think the last date is 30th. So your lordship may, without recording the concession, may say OBC stroke ACBC. So that would suffice. But this year, I have told them that you give a concession this year. But from next year, we'll come out with the policy. So there may not be any confusion. Because the last order, which my learned friend, in fact, I discussed with the Health Secretary and DMET also. Because DMET is not the authority to lay down
my observation, the court's observation is in the background. That see, you define SCBC.
Right.
Then you refer to that 1993 rule.
Right.
And then you say other than scheduled caste and scheduled tribe,
Right.
you have a list. you have a list of what? You have a list of castes.
Caste.
So that classification is on the basis of castes.
Right.
So they are other backward classes.
They are other backward.
Other backward classes, you define them, rather you describe them as SCBC. That can be done.
Right.
But with the same as laid down by the Supreme Court, that even for SCBC, you will have to have creamy layer thing.
Absolutely right.
So that is
But
that is
the
the-
lordship would refer to OBC. That some castes which will not find place in the SCBC list may not be there in the OBC list. So that would be not, rather it is a broader list. SCBC list will not contains the names of more castes than the OBC. So it is a broader list of Orissa.
it is not, yes, of Odisha.
Right.
Your list must be having list of castes of your state.
Right. That is
And persons belonging to Odisha
Orissa.
of that caste are entitled to a reservation.
Absolutely. I go.
This is
Because,
the
suppose a Chosa particularly. Chosa in Odisha may not be a backward class in other state will not also. Because in Andhra, it may not be recognized as a
And-
backward class.
and suppose there is Chasa caste in say Chhattisgarh also.
Right.
But that person cannot claim a reservation here on the ground.
Absolutely. That's correct.
So this is
Suppose I am giving another example, Jat. Jat in Haryana is not OBC. But Jat in the central list is OBC.
yes.
So somebody may get an appointment in UPSC examination.
Yes.
But he may be disqualified in the Haryana Public
Right.
Service Commission.
Right.
That's the.
That is the
Yes.
that is
Lordship
the
may say SCBC stroke OBC for the current year.
all right.
For this.
All right, we will write order. We will go through the report.
So Acharya, what I had noticed that is there in your scheduled tribes and scheduled castes, that notification of 6 January 2024.
Yes, Meena.
Please refer to definitions 2G.
I have seen that also, Meena.
So that refers to
Yes. To
admissions.
E, Meena.
2G.
To, yes, EF, that your lordship is referring to the 24,
January 2004
Yes.
notification.
educationally backward classes includes other backward classes declared by the government of India in relation to the state of India.
G. 2G definitions, creamy layer.
Creamy layer. No, before that, your lordship
No,
may
no,
kindly
before
see.
that,
Yes.
where you have
Means
specified
members
that.
of backward class who are highly advanced socially as well as economically and educationally. The people falling in the creamy layer category described in Appendix A are not eligible for reservation in services posted under government of India. That refers to
Thereafter.
educational professional benefit
So this,
and
the converse,
educational
the
professional.
converse means if they do not belong to the creamy layer, they are
Yes,
entitled to
yes.
so this admission here. But he is saying that is not there, that is there. This is not there.
When criteria is
Define.
must be a backward class.
So if it means that creamy layer is not, so non-creamy, they are issuing certificates for non-creamy layer.
Hmm.
This is for this purpose also.
That is not in dispute. Creamy layer melody is always there. That is also.
No. You said that there is nothing regarding admission to institutions. So this is necessarily means that those who do not belong to the creamy layer
Yes.
will be entitled for reservation to educational and
I'm
professional.
not telling. But Millard, so far this policy admission into educational institution, I have already told them, give them 11.5. If you are providing reservation in was, we are coming out, Millard, with that policy.
This does
Yes,
not
yes.
talk All right, we'll pass on it.
There are the 5 petitions before your lordship. First one has got the OBC certificate. He belongs to the majority.
Professor, we are not, I know that, sir, we are not, we are extending it. Why are you? Reserve project, I have already submitted. We are going.
All right, reserve category, but where is the provision?
Has been defined to why?
Where is the provision for reservation?
That's correct.
Well,
It is not there, we are not
And
giving
Mr.
it.
Advocate General is fairly saying that it is not there, it can be there, and they are going to have a policy to extend it. Can be done.
My lord, all read the bill. DPC.
Yes, first writ appeal.
Page 23.
See, same matter. Let it come tomorrow. Let us go through the reports and then
Tomorrow.
tomorrow.
Item number 1.
May I please? Your Lordship wanted to see the policy, but before, I'll just recapitulate on my submissions it had made. The brief background of this case is that the writ petitioner, the respondent in my case, he joined as a clerk in 1982. In 1997, he took the promotion test.
You are appearing for the bank.
I'm appearing for the bank.
And who is appearing for you?
Himself is a fitness.
In your case, one amicus curiae was appointed before the learned single judge. So he can appear for you. He had given a very good assistance as we see from the order.
Let me allow.
Yes.
He joined the bank as a clerk in 1982. In 1997, he took the departmental promotion examination and he succeeded. And from clerk, he was promoted to the post of JMGS 1. In junior management.
Yes.
Junior management grade scale 1.
Yes.
Now on getting promotion, he gave a letter to the bank that he wanted to forego his promotion. The bank accepted it and he was reverted back to the position of a clerk. Now thereafter, he again made a representation that I want to withdraw my previous representation and take the promotion. This was not acceded to by the bank, for which he filed a writ petition. During pendency of that writ petition, interim order was passed allowing him to take the promotional test, the next level. He took the test and in terms of the orders of this Honorable Court, the results were kept in a sealed cover. The writ petition was ultimately allowed in his favor. This Honorable Court said that no, he should be granted the promotion. And besides, his service would be counted from the day, but he would not be entitled to the financial benefits. Thereafter, my lords, he took the position of JMGS 1 in 2012. He continued there and he claimed promotion to the next post. Now, at this juncture, he again approached this Honorable Court. He said that my juniors have superseded me, hence, kindly grant me that promotion.
No, but he had already appeared in that examination.
Yes, sorry, my lords, I left out that portion. The seal cover was opened and he was found to be unfit.
Yes.
For promotion. Now, my lords, at this juncture, he again approached this Honorable Court and this with a prayer which your lordships will get at page 27 of the brief. In the learned single judge's order, he has quoted the prayer. Kindly see page 27.
Yes.
1 is to declare the petitioner promoted to the post of MNGS 2 during the year 2003-4 with effect from 9/2/2004.
to do away with the requirements of mandatory assignments and tests as have been complied with, and to award the petitioner with further promotions notionally to the grade of SMGS 5, allowing consequent pension entitlements to which the grade of the junior to the petitioner has been considered and promoted in the meantime. So he wanted promotion 5 levels up. Now, this was opposed by the bank on the premises that the promotion policy of the bank there are 2 channels. One is the merit channel, the other is seniority cum merit. Now, as far as seniority cum merit is concerned, I had shown to your lordship the salient features of the policy, which were a little confusing. I have the full policy before with me now.
No, whether this policy was taken into account by the learned single judge.
It was. He has considered that. I'll show it to your lordship in a moment. But before that, your lordship may kindly see this. The flat page, my lords, AARF score.
Yes.
Merit channel. Promotion to MMGS 2. That is the next level to which the petitioner was claiming to be promoted.
No, petitioner just a minute. The respondent is claiming under this.
He is
merit channel.
No, he is seniority cum merit. Merit he is not claiming. The officer should have secured an aggregate of ARF mark number so and so during the best 4 out of 5 years of ARF present grade. Seniority cum merit. The officer should have secured a minimum of 50 in each of the best 4 out of last 5 years ARF in the present grade. So this was the confusion, my lord, whether it's 3 years or 5 years, but it's very clear in the policy that as far as he is concerned, it is 4 out of 5. Now, let's.
Yes.
It's simple arithmetic, my lord. As far as ARF marks is concerned, this is awarded on the basis of his performance in that position. He came into the position in 2012. He's come before your lordships in 2014. He did not have the requisite number of years for assessment. The bank, it was not open for the bank to give him a notional mark for those 2 years, which were not there with it. So this is where, my lords, the honorable single judge has gone wrong. Page 45. Page 45, the table which he has extracted from the promotion policy, which was given by way of an RTI reply to the petitioner's query. As per the promotion policy, best 4 out of 5 years of ARF marks in the current cadre, that is MGS 1, are required for consideration of the promotion of MGS 2 for the year 13-14 as per the revised policy applicable for that particular year, that is 2013-14. Since Sripati has not completed 5 years of service as officer, the material time, he was not considered for promotion. Now, thereafter he proceeds, he says, at page 42, page 46, paragraph 42, it is thus clear that the opposite parties have denied the right of consideration for promotion to the petitioner for different years as mentioned in the order dated 1/4/2013 and action 9, apart from violating their own commitment and doing so, in addition to that non-consideration of the candidature of the petitioner for his promotion to MNGS 2 cadre for the year 13-14 for not having minimum eligibility of service experience and not considering the case of the juniors, extending the benefit of promotion to the juniors, ignoring the legitimate claim of the petitioner is patently fallacious. This is what I am saying. The bank, it was,
when was he promoted to MMGS1?
he was not promoted. JMGS1, he came into that position in 2012 pursuant to your lordship's judgment in the previous writ petition.
JMGS 2000? JMGS1, he came in 2012.
2012.
But when had he passed the examination?
In 98.
No, after clerk, when had he passed JMGS1 examination?
From clerk to JMGS1, 98.
98.
From JMGS1 to MMGS2, he failed.
No.
That examination he took during pendency of the writ petition.
That is not the question. The question is that he had written examination for promotion to JMGS1 in 1998.
Yes, sir.
In 1998. Thereafter, he had applied that he wanted to forego the promotion.
Correct.
That was
indicated by the bank. That was accepted.
That was accepted, and subsequently he wanted to withdraw. That was rejected. Thereafter, he came to the High Court.
Yes.
So, what is the decision of the High Court? Everything will depend on that.
The High Court's decision is this, whether that is also extracted. I'll just show to you. At page 28, Manoj. Page 28 of the brief. The Honorable Civil Judge has extracted the judgment. Para 9, Manoj, which has been quoted from that judgment, is relevant. May I read it out?
Just a minute.
Page 28.
Yes.
In para 3D, para 9 of the previous judgment is quoted. We are therefore of the view that the order directing reversion of the petitioner at the post of head assistant would not have been passed in view of the representation dated 2199 filed by the petitioner, withdrawing his earlier representation dated 7/1/98, on which the bank had not acted upon till the petitioner joined in the promotional post. Apart from the above, it also appears the petitioner was not only allowed to join in the promotional post.
So his right flows from this order.
His right flows from this.
You cannot treat him to have been promoted. Yes, there you are right. That maybe that we will have to consider that because
he did not have 4 years of appraisal.
Because the decision was rendered in 2012. No.
11.
No, this judgment came in 2004.
No. It came in 2011.
2011.
Page 43. At page 43, order dated 1/12/2011. In December 2011.
Your action of denying him promotion to JMGS1
yes, sir,
was not accepted by this court.
Was not accepted. Correct, Manoj.
Therefore,
Absolutely.
he was to be, and rather this is the observation of the court, that he was to be treated in JMGS1
from 98.
From 1998.
Yes, Manoj.
So, only on the technical ground that ARFs were not available.
Yes, ma'am.
And therefore he should not be. That is very.
He has not worked in that position, and hence he would not have been appraised for performance.
He cannot be blamed for your fault.
Correct, Manoj. But Manoj, the problem is this, Manoj. We are bound by a policy. And in terms of the policy, we have to make the promotion in terms of the appraisal reports. So if we do not have the appraisal reports, Manoj, how do we appraise? How do we consider him for promotion to the next?
You consider, you develop whatever policy you want to.
Manoj, I can't. That is prohibited by the Supreme Court also.
What?
That I cannot add to the
and
policy.
You can do what you have done.
Manoj,
could you do what you had done?
Sorry,
you cannot do this. You cannot do this because he did not work for more than 4 years, but you could deny him promotion in JMGS1.
No. Sorry,
that has been held to be bad by this court.
That has been held to be bad by this court.
So his right is to be determined with effect from that date.
Correct, Manoj. But my lords, how do I appraise him for the next
That
level?
you have to decide.
One more thing, one more issue
Yes.
that I need to bring to your lordship's notice.
Yes.
He was given opportunity for taking the promotional examination because twice in 2014 and once in 2015, he did not appear in the exam.
All right, he'll not get. But he'll have to be given benefit arising out of his promotion.
Yes, madam.
From 1998 in JMGS 1 in whatever way.
JMGS 1 to MMGS 2.
Whatever.
My lord, that position. But here the learned single judge has gone on to give him promotion up to SMGS 5.
You will have to consider. The court cannot direct you to grant promotion, but you'll have to consider as if he was promoted in JMGS 1.
I bow down to that, my lord. We have to consider. But question is, while considering, is it open for me to give him a notional mark or a notional appraisal for years when he has not worked in that
In
position?
fact, this is a fit case where exemplary costs should be imposed for filing such appeals. Because unnecessarily he has been dragged. He was dragged in 1998 also, and today also he has been dragged. This is this is SBI. These institutions have the luxury of, they can rather enjoy the luxury of litigation.
No, but it's not a question of enjoying the litigation matters. It's a question of, because this will
see, the matter would have been different. The matter would have been different had you challenged that decision.
Yes, Madam. That
So you
ought
did
to
not.
have been challenged.
You did not.
Challenged because there was a mistake on the face of it. There was a mistake on the face of the order, but bank in their wisdom have not challenged that. Today, my lords, we are in a piquant situation where we are bound by our own rules and we do not have a way forward. Now, my lords, one more thing which I also need, since I'm canvassing this point. Yes. Your lordship knows in this, as far as promissory estoppel and legitimate expectations are concerned, they stand on different lines. As far as legitimate expectation is concerned, it's based on a public policy. Estoppel is based on a private right. Now, my lords, here, my lord, again,
In this case, neither promissory estoppel nor the other principle will apply. It is his right to be considered. That is the only thing.
But, my lord, it's on the basis of these principles
maybe
that they learned
we learn
single
civil
judge.
judge applied, but it is a matter of his right to be considered. His right was violated in 1998. Where is the question of? All right, we'll pass on. You want us to allow?
He also has an appeal.
Huh?
He also has filed an appeal.
This one, his statements of the honorable counsels of the bank. I am just
That is our opinion.
Just my lord, one more submission which your lordship, I would request your lordship to consider. As far as promotion from the post of AMGS 1 to MMGS 2 is concerned, maybe, my lords, if that notional thing would have been granted to him, he would have been considered, or he would have qualified. Now, as far as promotion from MMGS 2 to MMGS 3 and from MMGS 3 to SMGS 4 and 5 are concerned, for that there was a test which he was required to take, and the opportunity was given to him. He has not taken that test. Can he be considered for those positions also, which the learned single judges granted? The channel is very clear. It is either merit or seniority come merit. Now he chooses not to
So
exercise that right.
even for seniority come merit,
Yes, madam.
he was required to participate in any.
Yes, madam. Yes.
So he was given opportunity.
Unfortunately, he did not take the tests. And where the court, learned single judge has granted him all cleared the entire channel for him. On the basis of both principles of legitimate expectation and promissory estoppel.
So your submission is that if he had appeared in those examinations and if he had failed,
Yes.
then he would not have been granted.
Yes, madam. Yes. Yes. That is my submission.
May I be permitted to say something on this issue? They say.
Can we hear him now?
Yes, that's all.
They say that they have the policy that if candidate who seeks promotion from scale 1 to scale 2 needs to work for 5 years. And he should have that, on that basis, he should have 5 years ARF marks. Now, my lord, when I was in reverted cadre, in reverted grade, I had appeared before the Honorable Court, as allowed by the Honorable Court, had appeared the test. Then they conclude a process and declare me unsuccessful, not promoted or not suitable. That is the word they have used. In that particular year, I had to work 6 years in one channel, 2 years in another channel. There I didn't work. There I didn't work as an officer, neither for 6 years, not for 2 years. Then I didn't have the 6 years ARF or 2 years ARF.
That we understand.
How could they complete that process and declare me unsuccessful?
So what was your ARF in 2013?
ARF? I 100% marks.
100%.
100%.
14?
14 also 100%. Well, my country.
No, what is your submission now? That we have, forget that. This part we will deal with. What is your, why have you challenged?
My country is, there is no, there is also a provision in that the circulars that there is a way.
Why have you, see, the writ petition has been allowed in your favor.
Yes, ma'am.
You are challenging that order.
No, I am challenging for getting some extra benefits that has not been given to me. And there is also a.
What is that?
Financial benefit.
Financial benefit has been denied.
No, not has been granted, not denied, not granted. There is a case where I just cite. In Harpal Singh versus State of Punjab and the Honorable Court says staff who have lost promotion due to administrative error should on promotion be assigned correct seniority vis-a-vis his junior already promoted, irrespective of the date of promotion. That has been taken into account by the single judge, Honorable Singh Judge. And whatever they say that their policy is there, the policy goes on changing. The policy also having a
that we have understood that you are entitled to your seniority and the promotion.
Yeah, not only that,
subsequent promotion.
Again, during this process of this court case, I have been before the Honorable Court to apply, to permit me to apply for to appear the test for next higher course, but that has not been considered because of their false and fabricated.
So, is this submission incorrect? That you had the opportunity to appear in the examination?
No, I had the opportunity to appear for that particular ground only, without considering the order of the court, without considering my backgrade promotions. That they differ in submitting before the Honorable Court. The court asked whether you were.
Were you not? Did you appear in the examination?
No, I didn't appear because I was. Had I appeared, I would have lost my backgrade promotions.
No, we are not saying because. So you got a chance, you did not appear.
There is no chance. There is no chance of that. I not in second. I lost time telling you. There is a.
So they stated.
There is a promise there.
You were given an opportunity to appear, but you did not avail that opportunity.
I didn't appear, just tell you.
So you are explaining why you did not appear.
Yes. In section, in Annex 9 of my writ petition, they have given me promise that your case will be considered for promotion to all your back years, according to the orders of the Honorable Court, 2004 and 5 to 2004. on that particular year, that I am putting. But on the same year, they did not consider my case. Those 27 candidates, junior to me, were promoted without written test, without seniority, without merit. That is the one question. Without merit, no interview, no viva, no written test was conducted. But my case considered. I submitted 3 representations.
No, but they were promoted without following the procedure.
Exactly. That was
All right. Where is the procedure?
I can, you can just see.
Yes, yes, sure.
See, if you have to do some homework, please do
Yes,
there at your home. Please don't do it here.
No, it is there. They say that.
Yes, you have completed. He'll argue tomorrow. You have the competence to argue any legal point, relying on Supreme Court's decision, referring to and learned single judge had given you this opportunity to have an amicus, and here you have refused.
No, I am
And you are turning to papers here.
No, because you are wasting time, we are keeping it to tomorrow so that you come prepared with your points and refer to the points and refer to the pages instead of looking here.
Okay.
All right. You saw how the council submitted, so that way that is why you were asked, given the chance to take help of legal counsel.
Instead of tomorrow, can it be here?
Okay.
Yeah.
Item number 2.
Yes.
Present here.
Yes, do you have the list?
Yes.
You are the secretary of the commission since when? Since when you are the secretary? Since when you are the secretary?
Sir, joined in the month of June, sir.
In the month
Last
of
week
June.
of June.
This year.
In charge, sir.
All right. So how many posts were advertised?
198, sir.
198. What was the how many posts were for UR?
It was, sir, 126, sir.
126. And reserve category?
Sir, in schedule caste 29 and schedule tribe 43, sir.
29.
Sir.
Schedule tribe?
43, sir.
43.
Sir.
All right. So this is the you must be having this list which we have.
Yes, sir.
All right. Now come to serial number 126.
Sir, one thing to say, sir. 126 it was advertised, but government had sent a letter, sir, to only to recommend 121 UR candidates. Because 5 candidates of 5 cases were there regarding contractual and regularization of 5 doctors. So 121 UR were recommended.
All right. So let us come to 121.
Sir.
(121) Loma Pudra Jena.
No, sir. Okay. Actually, sir, 121, sir. In between, sir, there are some court cases. Sir. There are some court cases.
Court cases means?
Sir, some persons are challenged. For which the court cases were being.
Court cases were to be rejected from the merit list because
Sir,
there were
yes,
court
sir, yes,
cases.
sir. The court order was there, the tribunal order was there.
What?
Not to publish the result of the inspection, sir.
Uh, this is the merit list.
Yes, sir.
What about
Come.
111?
Come to 110.
110.
Oh, ST is coming.
110, sir.
Come to 110.
Yes, sir.
So whether he was required to be there in the merit list or not.
No, sir, he is not in the merit list.
Why not?
Sir, because that case has, sir, I have the details of the cases. The petitioner did not possess the required qualification in Odia case. We had a advertisement that was there, the candidate must have a Odia standards.
All right. So for whatever reason,
Sir.
So up to 120, we will come back after 2 minutes.
Yes, sir.
All right. In the meanwhile, this is the revised merit list.
Yes, sir.
And this is not revised merit list. This is the merit list.
Yes, sir.
All right.
Yes.
So we will give you 5 minutes time to tell us up to which number UR categories should have been selected, SC and ST, 3. It's a 5-minute job.
It is in there, up to 130, sir.
Tell us, so we'll come back. We'll come back within 5 minutes. In the meanwhile, please do it. And we'll wait for you to do it in the court, in the courtroom. All right. All 3 things. This 121 will go up to what? And then we will put questions.
120, sir.
Serial number 120.
Yes, sir.
Amrit Kumari Sahu.
Yes, sir. 130, sir. 130 is 20, sir. Gargi Mahanti.
Lots of what has happened in this case is they have prepared the merit list. They have prepared the merit list in a descending order, my lord, in terms of the merit. But since there were cases which were being pending.
130.
Yes, sir. Up to serial 130.
130. Up to serial 130, how many candidates?
Sir, 120 candidates.
120.
Yes, sir. In between, one ST candidate is there.
No, ST candidate can be there.
Yes, sir. Due to age relaxation, sir. ST candidate, since she has availed age relaxation, she will come under ST candidate.
You're right.
So 119.
All right.
119. Thereafter, sir, we have taken
119.
Yes, sir. 130 serial is 119, sir.
So ST goes. Just a minute.
Sir.
Where is that?
ST is at serial number, sir, 111, sir. Lakshmikanta Patra.
Yes.
Sir, then we have, as per the rules, sir, we have taken 2 candidates, one physically handicapped, sir.
Horizontal reservation.
Horizontal is a blind candidate. It is at serial number, sir. Sir, at serial number, sir. 486, sir.
Yes.
And one sports person candidate is at serial number 518.
So this is how you have 121.
Yes, sir.
These persons were recommended.
These persons are recommended on the UR category.
UR. So the cutoff comes to 192.423
in UR category.
In UR. Now tell us
Sir.
who are working,
Sir.
who have less score
Sir.
based on revised merit list
Sir.
than this cutoff 192.423.
Sir.
Whose names were recommended.
Yes, sir. They are, sir, at serial number 137, sir. Selli Roy.
Yes.
140, sir. Parmistha Swayamsri Udgata, sir.
Yes.
Thereafter, sir, Monisha Mahapatra. 141, sir.
This.
So thereafter, sir, Jimmy Monisha at 144, sir.
Yes.
So thereafter, sir, Bhagyasri Sahu at 155, sir.
Yes.
Thereafter, sir, 101,763.
A serial?
Serial number, sir. Sir, 161, sir.
161, yes.
Sohida Tabasam, sir.
Rajan Raman.
Please, sir. Sohida Tabasam, 161, sir.
Yes.
Sir, again, 163, Puja Priyadarshini Parija, sir.
Yes.
Sir, then Sripad Prada Das.
Where is he?
So that is serial number 182.
83.
Sir, sir. Yes, sir. 183, sir.
Yes.
Thereafter 184, sir, Debasis Sahu.
So these persons are working.
Sir,
Now tell
they are
us.
in your category.
Huh?
They are in your category, and another one SC candidate is also there.
All right. Now tell us who are the persons above in this 121 list who have not been recommended. You were required to recommend 120 persons. You have now revised merit list. So in view of revisions, marks of some candidates must have gone up.
Yes, sir.
So is this your case that from 1 to 121, all persons were recommended? 120 up to this 131. Everyone was recommended 130.
All have been, sir, recommended, sir. 121 candidates in the list of 130, sir. 130 and 2A, all have been recommended.
Please, check.
And recommended means we have sent the list, sir. We have sent the list and to send the list to government, revised list and select list, and we have told them the unsettled, not to settle the unsettled. We have told previously. So
you did not recommend. Do you understand the meaning of sending the merit list and recommendation? So did you recommend?
Oh,
you did not. Right, you did not recommend.
You just inform.
So we want to know. All right, we want to know that who are the persons who are above in the, whether the questions which we are putting is something, whether they are complicated or new, or it could not have been imagined.
Sir, Those were not in the previous list, but they have been there in the.
Yes, as simple as that.
Sir, they are in the Kaushik Patnaik.
Huh?
Sir, Kaushik Patnaik.
Where?
Sir, I'm just telling you. 205.46. Sir, no, we didn't. The revised list did not hear the website.
That means.
And that list was published on the website.
A previous list was.
So do you?
Okay, but the category is not aware, so that it's all right.
All right, let us understand. Give us the name.
Kaushik Patnaik, sir.
Item.
Serial.
Serial number, sir. I'm just telling, sir. 1469. Serial number, sir. Is 37, sir.
Yes.
Then, sir, Umon Tripathi.
Item.
Sir, I'm just telling, sir. Sir, our serial number, sir. 100, sir. Then Boransu Patnaik, sir.
Serial.
194. Sir, Boransu Patnaik, sir. 113, sir.
Yes.
And then, sir, Juben Mohanty.
116.
No, sir, I'm telling, sir. Yes, 116.
Yes.
Then Mona Lisa Swain.
119.
Yes, sir. 191. Oh, yes, 119. Thereafter, Gargi Mahanti. 130.
That's all.
Then one sports person was also previously not there. It is a serial number. Sports person.
Serial number.
I'm just telling, sir.
Give the name.
Ansuman Raut. Yes, serial number 101101. Sorry, serial number 518.
518.
Yes.
Sports person.
Yes.
So he should have come in place of. No, 5118 has been given.
You've given 518.
No, not in the previous list. That was in the year list. In the revised list.
No, you gave us that number saying that he has been appointed.
No, not you. Earlier he was not appointed.
That is all right.
But we have in the revised list, his name is there.
And you have recommended.
Yes, he recommended means we have intimated the government to this the previous.
No, but earlier, who was appointed against, recommended the sports quota?
No, sir. Sports quota was that candidate was not at that time not qualified. After the revision of answer key.
So you partly implemented your revised list.
Has he been appointed? 518.
That is not.
Not within your knowledge.
That is in the government's knowledge.
Best part.
Government has to take.
So once you have, you don't even know.
Previously, no sports conduct was recommended, but in the revised list, it is.
All right. So your cutoff of UR is should be 192.423.
Yes, sir. Yes, sir.
What about SC?
SC cutoff is.
Revised.
The revised SC cutoff is male 130.549, one female is 130.904.
So we will again have to do the same exercise. Like because of revision, some persons below in the merit list
Yes.
might have been earlier recommended, they are working, and above in the merit list, they have not been recommended. So can you prepare a chart and give us? Now you have understood the questions which you are putting. So can you prepare a chart? And why did you not upload the revised list?
We will upload.
For 7 years. Permit quoted.
Yes, what is your score, Mr. Samal?
I have not, in fact,
No.
this list.
What is
Where are you in this?
Very, my lord, some contractual appointment was made in the background.
forget that.
There is no specific direction.
Mr. Samal, we are trying to understand your position on the basis of revised merit list.
So, Lordship, page, serial number 133. your Lordship.
Page 9 of this.
Just a minute.
Serial number 133.
133 Anil Kumar Sahu
Anil Kumar Sahu and 138 Sanjay Kumar Panda.
and
38 Sanjay Kumar Panda.
yes.
Sanjay Kumar Panda is the respondent in this proceeding and the connected case. Anil Kumar Sahu. If the post advertised will be filled up 126, we are coming within that. And that apart, 5 candidates, they have mentioned the name in this list. They did not join. Their name has also been indicated in this list. So also,
No, now nothing can be done because those posts must have been advertised in the subsequent.
no. Thereafter, according to the government, wrote them to sponsor 5 other names
Because it was vacant.
because it was vacant. Then they recommended the 5 names whose name found place at serial number 200 something. Not within this. If those 5 posts would have been given on merit, then I could have got it.
So, after the revised select list was published,
Yes,
the persons who were not there in the list earlier,
yes,
but came into the reckoning, they were not informed, so some of them have not been appointed.
not appointed.
That apart,
That apart,
government said that give us 5 names.
yes.
So new 5 names were given, but on basis of what?
On the that is
That was
that
earlier.
we can
That was
that
earlier.
we can apply.
That
That
was
was
earlier
earlier
to
to
revision.
revision.
That was earlier, not
Before
before
the
revision.
revision.
Yes,
That is before revision.
Your Lordship, the revision was made on 5/10, according to them, on 5/10/2018, the expert committee submitted its report to them. Thereafter, they recommended on 7/3/19 4 names and
Just. So this is correct, that first the revised, before the revised list was published, those 5 were recommended for appointment.
Yes.
No. After revision,
No,
or
sir.
before revision.
Before
Before
revision.
revision.
Before revision.
Before revision.
So,
We have the letter memo.
just 1 minute. So those 5 names you have not yet told us.
This Loknath
Mr.
Sarangi,
Tripathi,
Monal
Mr.
Safi.
Tripathi, so those 5 names, we have not yet been informed the
So they are in
position,
the
or you have told us.
Out of them,
Do you understand the question?
division के बाद होती होगी.
This means for you right now, we can write down. Those are the 5 persons.
That's only one page, page 95 of the brief. Page 95.
What for?
So, on 17/2/2022, the Secretary of PSC re-evaluated our answer script as per the expert committee report and intimated to us that in pursuant to the order dated 15/11/21, 26/11/2021, passed by the Honorable High Court in WPC number the batch of cases, this commission has considered the case of the applicant by scrutinizing the answer book again by taking into account the report of the expert committee. It is found that the cutoff mark finally selected candidate URM category 189.558 and UR female is 180.360. Considering the expert committee report, the secretary intimated to us that the cutoff mark is this. How can he change his version?
to be fair enough, when the first order was passed, that time they had not acted upon.
That means
Only when, my lord,
this is
the
a wrong-
contempt was filed.
This is a wrong statement.
The contempt was filed, my lord. Thereafter, they implemented it.
No, forget about all this. What he says,
Yes, yes, my lord. I completely bow down.
correct or wrong?
I completely bow down, my lord,
Bow down to what?
to that OPSC's, my lord, the disposal order. Wherein
No, the letter
Yeah.
which has been,
that they have disposed of. The
no,
presentation.
not disposed of,
Yes,
the
yes, ma'am.
contents of that letter,
The contents of that letter is in
giving the
pursuance.
cutoff.
Yes, contents of the letter is in pursuance to his disposal, ma'am.
Forget about that. The contents of the letter
Yes,
is
yes, ma'am.
correct.
Yes, madam. That time they had not acted upon, so they have written that, my lord, which is incorrect according to me.
Exactly, correct or incorrect?
Is it incorrect, ma'am? According to
Secretary says that as per the expert committee report, we are determining. Same secretary.
Commission only took the decision in 25th July 2022 to implement that expert committee recommendation.
Because the contempt application has been filed, you will give whatever you feel like. And if you have given a wrong letter, you could have again sent a letter saying that that was incorrect after.
We passed another order which was under challenge. We passed another order which was under challenge before the Lord and single judge.
That order is at page 108.
108.
No mention of cutoff mark. Page 108. All these pleas are taken sports quota and physical handicap quota. They did not fill up within 171. When I filed the case and the case was allowed, then they are taking this plea. Their name was never recommended. Prior to that, even they cannot produce a scrap of paper showing that we had brought this fact to the notice of the Honorable Single Judge. At that point of time, that was not there. Because to out these two respondents, they are taking the plea that someone at serial number 400 some odd.
Mr. Counsel, the whole question is that whatever order was required to be passed by the learned single judge in that writ proceeding, that was to be done in accordance with the revised merit list. That has not been done. So cutoff marks as fixed earlier will not remain the cutoff marks for the subsequent based on revised merit list.
The Honorable Single Judge have categorically asked the learning council for appearing for
Forget
that you have given appointment to a candidate who has secured 184.
Mr. Sama, please let us accept that all these facts were not before the learned single judge. Now we have everything.
Yes, my lord. When my lord, one candidate securing same examination, 184, is continuing in service. I have secured one.
That is different.
That we have
That question is
understood.
different.
That is why we asked for that
Yes,
list.
yes, yes, ma'am.
In the previous merit list, sir, also the blind candidate was there. Only the sports person candidate, since he was not qualified as per the government rules. So he was not.
Mr. Secretary, just imagine a situation where you had recommended names on the basis of the previous merit list, and thereafter you are suggesting the government that don't act upon the revised merit list because that will unsettle things which are settled, and then you are making a recommendation on the basis of a revised list against sports quota. This is not a mockery. It's a constitutional body.
Why do you say he was not qualified earlier and subsequently became qualified?
That was 50% for the UR category qualifying marks was there, and after the revision, sir, madam, after the answer key revision, the marks was announced.
Minimum mark.
Minimum mark was.
Okay.
Qualifying marks is got, otherwise it's not qualified. Qualified. So we will be qualified. So he recommended. Persons have been appointed
The
at
government
blind
will
fellow
say.
and sports quota.
Oh, that, today only I got the information there. I don't have any idea. I'll have to take instruction. About that, I don't have.
It must be there.
Sorry, ma'am.
That list must be there. Because what they have done, though they are saying that these persons became qualified, they have not intimated those people.
Ma'am.
So if they got to know themselves and were appointed, or government appointed them, that is different.
Right.
Well, their instruction was don't unsettle the settled positions.
No, your lordship on 12/9/2024 asked the government council to give a reply as to Dr. Sanjay Kumar Panda, another is
Anil Kumar Sahu, they are the
to seek
applicants.
instruction.
They are the applicants.
I have instructions. I have filed an affidavit also.
Yes.
There, my lord, a committee was constituted, taking all the senior officers. After careful deliberation of the committee, unanimous result as follows. The 11 candidates who were allowed to continue pursuant to the advice of the Odisha Public Service Commission have no right to continue in service.
That probably after obtaining orders of the court. That,
yes, ma'am.
that we have seen. Why orders of the court?
Yes.
No, why push it on the court? It is your defect. I mean,
No.
your fault. Then the court to say that they should remove. They won't take the responsibility. That we have seen. What about the persons who became entitled for appointment but do not know?
Yes.
It is possible they may have appeared again, and but this is so. Just imagine.
I can understand.
Only these two people are vigilant, so they have and they have come up here.
They have come up. Some other persons may be there.
Even the state council, the state government has prepared a merit list. Seniority, not merit. The person who has joined, they will maintain a seniority. Suppose X are not selected but not joined. We can learn Apna who have been there in the seniority list.
Yes.
Or somebody has.
Yes. Who is not joined, but they have
They have mentioned name of 5 candidates, serial number 3.
who have not even joined.
They have not even joined. This is the state of affairs. In my affidavit, I have categorically stated these persons have never joined. Their name because their name was only recommended by the OPSC.
Not recommended.
Their name was recommended by OPSC, but they did not choose to join in the government service. But they are
Previous list.
yes.
Because second list they have not recommended. They have
Not
only
recommended.
mentioned. So you are
Previous
talking of the previous list or the
previously.
That is why they asked for 5 candidates.
No. I am talking about a seniority list maintained by the government in the year 2024, 13/3/2024.
So are you saying that the government said that 5 candidates have not joined? So you give us 5 more candidates.
Right.
But as per the merit
Seniority-
seniority list, those 5 names are there.
Yes. Instruction, serial number 3.
That is
See,
the fact.
you have.
I don't have, my lord, the information.
The commission has taken a decision not to rectify its mistakes.
Now we have written, my lord. After your lordship's intervention, we have written to the government.
Where is that?
Why did not say it is your
We wrote a letter, my lord, which is a. Fourth.
That less meritorious persons, because of the revised merit list, were recommended. And yes, they were recommended on the basis of the merit list which was existing. So subsequent to revised merit list, you have not done anything. So this is the decision of the commission. The final that yes, this is revised, the court directed, we have revised, nothing else.
We had written letters in the written earlier.
As per the government. This is very good.
We had written a letter, my lord, to the
And
government.
despite the fact that we asked you to take a decision, we have decided that let the court decide.
Commission is only taking a leave of the honorable court, my lord. They have resolved to recall, but right at this point, since the case is pending, they are not in a position, my lord, to write to the government. They have.
So you've written to the government, that is why the government says this.
No, my lord, we have resolved with regard to that. We cannot. My lord, earlier we had written.
File an application. File an application, we will allow. Make an application. This is also for the reason that there is an order passed by the learned single judge. So during the because of that order, you may not be. You file an application, make an application. Tomorrow we will pass order. Permission, the court will grant you permission.
But okay.
But at least bring these facts. The way we put questions to you, you just make an application accordingly. We will give you permission.
We will.
We will see what can be done with you.
When were the appointments done as per the previous list in the year?
171 for an appointment. Rate of appointment.
Unrevised list on sir, जो पत्ती आ गई.
2019, because for some of
Pursuant to our court's order dated. So the Secretary, Orissa Public Service Commission is present. So he has filed an affidavit has been filed on his behalf.
It has probably been e-filed. Annexure put out, she can go scan.
I have given the original.
No. Have you filed it or you
No,
put the
we'll
original?
file it, my lord. We have given now.
Original.
Filed an affidavit bringing on record the the revised merit list in relation to recruitment to the post of dental surgeon, pursuant to advertisement number 15 of 2017-18. Stop. The said revised merit list was prepared in 2022. Was prepared way back in 2022. First off, we have been told that the said revised merit list has yet not been put in public domain. First off, we direct the commission to put the said revised merit list on its website by tomorrow, indicating the circumstance in which the said revised merit list had to be prepared. Let us list this matter on Thursday. Today is Tuesday.
Monday.
Wednesday?
Next week.
Wednesday, this week. In the meanwhile, you can find what problem do you have? Because see, we feel very sad about it. That we have not been able to decide. It's a very simple question.
Thursday will it be, my lord? Thursday will it be possible?
Already Thursday to be taken up at 10:30. Stop in the Secretary Public Service Commission. Shall be required to be present again on Thursday.
Yes,
Item number 4.
Then, madam, in the meantime, let the non-state council take the instruction. Who are the candidate who has been appointed person to that act?
In the meanwhile, let an affidavit be filed on behalf of the estate of Odisha, stating Odisha bringing on record the names of the candidates who have been appointed pursuant to the advertisement in question, based on recommendation made by the PSC. Name/list.
If there is any other recommendation pending with the government, if any other recommendation of OPSC is pending with the government, let them apply to this one.
Recommendation?
Suppose OPSC has recommended some more name, but no appointment has been made. Now the OPSC taking 2-3 stands. They are submitting that we have recommended to the government. If apart from the appointment, is there any recommendation of OPSC pending?
No question of recommendation. He is saying, Secretary, see, he is an experienced officer. It is not that he does not understand the complexity of the issues, but he is also in problem. It is not easy now for the commission to resolve. So if they take some bold step, then it is easy, not very difficult.
Item number 4.
Item number 4. It is a deputy master, bachelor in physiotherapy course. We have already recommended to government for issuance of NOC. Now it is if you are not recent, it is regarding D Pharma. We have already recommended for NOC.
But Council of the DMET has submitted that the DMET has already recommended to the government for grant of NOC in connection with the institution in question for D Pharma. D Pharma. ये है in WPC 20490.
In the rejection list, they have mentioned both D farm and B farm. No, the recommending is the D farm.
So you applied for what?
Both.
No, here?
No, this case only.
D Pharma they have recommended.
Yes. B farm, what they have, my lord, subject to, then if that can be taken up by your lordships, I'll just show a couple of documents. Because what they suggested us, after they did the inspection, the lordships can have a glance at the brief at page 52.
This 19066.
25445. Item 4, item 5.
Where is your decision, Mr. Monty, in this case?
That is not there in his document.
Yes, well, that was B Pharma we have already given, which was not correct. We withdraw that. He was asking for D Pharma, and D Pharma we have already given.
That is not there in your instructions.
Instruction is only for D Pharma, we wanted to give, and we have given to D Pharma.
No, this is WPC 20490 of 2024 and 19066 of 2024.
Different. I think there must be one more. Out of the three. What is this? You are confusing us with different document.
Might not what has happened. D Pharma we have given two institutions. In D Pharma and BP2 have given two institutions recommended. I have got the tick mark.
The tick mark for document you have not submitted. That's
Yes,
why we are confused.
Yes, your lordship may have a glance at page 52.
24658.
No, my lord, the other one, 25445.
2, 5.
That is item 5, my lords.
Jagannath School?
Yes.
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 So do you have any instruction regarding that?
B farm, they have not given.
Just a minute. That item 5 is not there in your documents, unless you have one more. Or you have given a wrong writ petition number, 19066 is supposed to be yours. It's not.
19066, that was the earlier writ petition, which was withdrawn and.
Withdrawn because.
No, because the subsequent, my lord, after we got the PCI recognition approval, then we came back before your lordship.
So this item 5?
4 and 5 both are.
No.
5 is
4 is included. 5 is nowhere there. That's why I'm asking.
5 you have recommended. 4 you have recommended.
4 is there.
DB.
26458 is fine. Last.
Both, my lord.
That has been
Both were given by-
Both.
both
All
were
right.
given.
Then the DMET has already recommended to the state government the petitioner's case for grant of NOC for D Pharma courts.
D Pharma and B Pharma. Both.
D Pharma and B Pharma. D Pharma and B Pharma courts. ये ऑर्डर है ना, ये देखो ये WPC नंबर 25445 of 2024. Most of in such view of the matter, the present writ application stands disposed of. So now let us come to maybe both the cases. One had B pharma and B pharma, and the other case only D pharma.
Oh, sir.
That's for physiotherapy.
That is physiotherapy.
BPT.
In the other case, BPT. One case D pharma and B pharma, and the other case physiotherapy.
Bachelor of Physiotherapy.
4 and 5. 4 and 5. Yes. Which other case, Mister?
My lord, item 10, the petitions are there, 2 are pharmacy and others are of nursing. Their defect is their fire certificate.
So they are not here. Let the matter be
They are
called.
here, my lord. He is there. Item 10.
But I propose your lordship that we will approach before the DMET along with the relevant documents. If the DMET considers, then proper renewal may be issued.
Mr. Mohanty and counsel appearing on behalf of the.
My lord, there is already a direction that the institutions who are having valid fire certificate who will consider for registration, for inspection. If it is so, they are having a valid.
Just see the order.
Yes, sir. That order I have already.
We have also learned how to pass orders.
But these are unnecessary. There was no necessity for filing these writ petitions. No necessity.
If they are having the.
Yes.
Yes.
Mr. Mohanty and counsel appearing on behalf of DMET has submitted.
All the matters 42.
Just a minute, has submitted that because of certain defects. The
Deficiency.
deficiencies found out by the DMET, the petitioner's case has not been considered for, has not been recommended for grant of NOC.
Not recommended for inspection or grant.
For recommended for
Inspection.
for the purpose of grant of NOC. So, Land counsel appearing on behalf of the petitioner submits that he shall advise the petitioner to approach the DMSC for a removal of deficiencies. First off, it goes without saying that if the DMET, that it will depend upon the DMET to take a conscious decision on a conscious decision if the petitioner approaches it in accordance with the procedure prescribed. So this application stands disposed of accordingly. This is which writ petition?
It's for 10 and 11, your lordship.
10 and 11.
42 also the same.
Item
We have
6 matters.
Item 10, yes.
42, 45,
49.
48 and 49. All the same.
49.
Yes.
Means these, even without an order, you would have considered if they
Yes.
would have approached with the materials. So here only stage of time of the court.
Yeah. Is that over?
Yes.
42, 45, 48 and 49, 2 matters.
Yes.
Yes. So before the orders are uploaded,
I'm instructing. I'm instructing.
you can see the draft orders
Yes, sir.
before the orders are uploaded. Yes.
Case admission item number 6.
Basics, government came up with regulation for the purpose of appointment of teachers in government private schools. 582 posts were notified to the trainer. And elect list was prepared, in which the name of the respondent is at serial number 330. These are all undisputed things I am submitting. Some candidates filed a case before the learned tribunal. Respondent also filed a case before the tribunal. All the identical matters were taken up together. The learned tribunal directed that you must prepare the list category wise, appraise. Thereafter, alleging non-implementation of that order, some contempt petition were filed. Before the contempt petition could be disposed of, government released a fresh list. In terms of the fresh list, the respondent was given appointment. Government abided by the order passed by the London Tribunal by issuing a fresh list. In the fresh list, his name was there, he was appointed. That was in the year 2006. Now he claims that I should be appointed from the year 1996. That is the entire case is over. London Honorable Single Judge passed the order saying that he doesn't have any fault. That is why he should be considered to have entered into service in the year 1996. But our stand is, my lord, while implementing the order passed by the London Tribunal, we release the fresh list. That is the order passed. These are all undisputed submissions. They cannot.
So where is the impugned order? In section 2?
Sorry, my lord.
Where is the impugned order?
Impugned order.
Page 39.
And where is that order? WPC 919015?
39 is the impugned order. 9015 and 5320 is judgments. I'm placing that.
No. Single just says
Yes.
that this is squarely covered by order passed on 22/11/2017.
My lord.
So where is that order? He has just followed the order.
My lord.
Then what is wrong in it?
I'm placing it.
Well, I have annexed it in my counter.
Counter to the writ petition, sorry, writ appeal.
Counter to their writ
Writ
appeal.
appeal counter.
Running page. Annexed to P by 1. Running page. 13 minor of the judgment matter. The division matter that has not been overruled by me.
You want that to be overruled?
That has not been challenged. The order of the division bench has not been challenged at anywhere now. But I am pressing that order. The running page 13 minor of my counter matter.
This is the part of the order. It starts from
11.
Yes.
Page 11. Let me place the place is 11 months. Everything will be clear. The sum and substance of the case of the opposite parties, being the applicants before the tribunal, was that a selection was held in different education districts for appointment to the post of assistant teachers as per the guidelines issued by the government in the resolution dated 12/3/1996. Alleging gross irregularities committed in such selection, number of original applications were filed before the tribunal, including OA number 2792C of 1999. The tribunal, by order dated 24/1/2001, disposed of such original applications, directing the state respondents for preparation of select list categorized afresh in accordance with the instructions then in force, and the vacancies be filled up in accordance with the placement of the candidates in respect of each category. It was also directed that the procedure will be completed in all respects by 31st May 2001, and the candidates who have already been appointed to continue in the respective post purely on provisional and ad hoc basis, since such order was not complied with. CP number, contact petition matter, CP number 382C by 2001, and batch of cases were filed. Such contempt petitions were disposed of on dated 2/12/2004, wherein the tribunal observed that although the select list has been given to the directors of elementary education since 13/3/2003 for approval, the same was still pending, and accordingly, further time of 4 months was allowed to the state respondents to approve and implement the select list by disengaging those who have not been included in the state select list. Since the matter was further delayed and the order in OA number 2792C of 1999
and a batch of cases were not complied
Yes,
with.
so Run single judge has simply relied on this decision.
Yes.
And he had no other option.
Yes, I was also looking at as to whether it has been assailed. I didn't find any.
And
It
we
is also
find
recorded in that order. That is now, it has not been challenged.
So the AG has been very fair in his submission. The state of Odisha in the present state appeals has put to challenge an order dated 14/7/2023 passed by a single judge of the court in WPC number 14788 of 2023, whereby learned single judge has disposed of the civil petition in the light of a division bench decision of this court rendered on 22/11/2017 in WPC number 9015 of 2014 and WPC number 5320 of 2014. Party name there. So, following was the relief sought for by the respondent in the writ petition. So, next we have reduced this court's order dated 22/11/2017, which has been brought on record by way of annexure to the counter affidavit filed by the respondent in this case. In case of partition, in case of state of Odisha versus what is that? That
is my lord.
Kaila Sutta.
Kaila Sutta Devi.
Start days and others.
Sutta Devi. We are satisfied. The said order of the division bench in case of so and so was never put to challenge. Learned single judge, in our considered opinion, has rightly passed the impugned order following this court's decision, following the division bench decision of this court in case of self-supervision. We do not find any merit in the present writ appeal, which is accordingly dismissed.
Item number 8.
Yes, so it's for the, you are for the applicant. May not be necessary. It is not maintainable, Mr. The present writ appeal has been filed, putting to challenge an order dated 57/2024, passed in CMP number 579 of 2024 by learned single judge of this court, an order dated 9/4/2024, passed in FA 4 number 8 of 2023. By the Additional District Judge, Large Court, reversing an order passed by the learned Senior Civil Judge, Jajpur, in CS number 327 of 2022, was under challenge. First off, in our considered view, the present intra-court appeal against such order is not maintainable and is dismissed accordingly.
Item 9.
Counter is required to be filed.
Yes, ma'am.
Right?
Because it should be a separate status now. The matter so far interim order is concerned, not infrastructure, nothing else, madam, because addition period is gone. So other deficiencies is concerned, so they are not filing the counter.
Oh, but there was no direction for filing counter affidavit.
I think you were absent. Adjournment was sought for, so there is no direction for filing the counter affidavit. Is it necessary? Since you are saying admission is over, what is the requirement?
Yes, sir.
So the matter has become infructuous.
No, my lord. So far interim order is concerned, the infraction.
No. What do you want?
Around 2 weeks after, my lord.
No. 2 weeks. What is your relief sought in the present application?
So far interim order is concerned, my lord.
Forget interim order. This has come for admission.
Yes, ma'am.
So what is your relief?
My lord, others 25 matters is pending now.
We are asking you what relief have you claimed?
Yes, ma'am. My lord, in my petition, my lord, I am claiming for the allowing of the admission in my institution, my lord.
Which course?
My lord,
which course?
In ITI course, Industrial Training Center, my lord.
On what ground?
My lord, that institution has got a permanent affiliation, my lord. Permanently affiliated. In the sessions, mid of session, they are issuing the letter for the disallow letter. In the meantime, 25 to 50% seat already fill up. In the middle of the session, they allow, they issue the letter for the disallowing of the matter, students. So that's why we are giving the slow cast. In the meantime, admission not allowed for this session. But in old session, it is continued. So in this regards, they are filing for the disallowing, challenging the disallowing matter. So for interim order is concerned, not necessarily because admission session already gone.
On the deficiencies, will give a report to election.
That was the question where because some schedule type candidates were no.
Here it was that infrastructural deficiency, the schedule type also flows from the same point of logic. It was inspection was taken up on behalf of the central government policy lordship, and we have found out there were some deficiency, infrastructural deficiencies. So they were given a show cause notice, and a lordship, those who replied within time, they were allowed to take admissions with an undertaking that it will be resolved as a writ petition subject to results. And those who had not replied during the time frame of lordship, they were not given any interim.
So this institute had not applied. You did not reply to the supposed notice.
No, matter. So for Karan is concerned, we have replied.
Replied, but after the
No.
Yes.
Yes. In so your lordship currently to be the annexure 6. Annexure 6, as the present petitioner filed first email to the opposite party on.
There is no representation. Your so-called. So-called reply.
Yes, madam.
Where is that?
17/2024. Respect to the taking admission to trade does not. Our IT kindly solve this matter for the admission in student. The first representation. Thereafter, my lord,
Thereafter, they have filed another representation.
No, where is the so-called notice?
So-called notice is a matter, annex
Date
7.
probably given in
7.
July.
Annexure 7? No.
Annex 4.
Where is so-called notice?
Annex 4, my lord. Disallowing for the admission on 24-25 on the basis of the inspection report, the continue of the post merit scholarship. That is scholarship. That is not the other thing. I inviting reference subject I am to say that the physical verification of the private IT conducted by the officials of the government IT and ITC of the state, in accordance with the letter number Director Technical Education Training Odisha Kotak. The infrastructure for other facilities of the ITA has been found deficiency as per the inspection report. Now, the keeping view, the instruction training, academic, that is a common order. Common letter on letter other every IT out of 50 IT they issue. But neither indicated whether in the IT which is indicated with infrastructure or electricity.
But you were asked to give a reply by 9/7/2024. So that she was pointing out that institutions who had given their application or whatever before 9/7, we had permitted them to admit students. So thereafter, have you given any show cause or anything?
Thereafter.
Where?
Thereafter, I have given another 27/9/2024. Annex 6, running page 27.
Copy of reply letters.
That is a reply.
Where is that?
That is running page.
I already filed representation. I have got permanent affiliation that it is humbly said institute has been.
Annexure?
Annexure 6 series running page 22, my lord.
There is nothing.
There is.
Yes.
There is a letter.
Allowing the students for the admission. Sir, respectfully, I have already filed a representation through Gmail on dated 7/8/2024. Our institute have got the permanent affiliation in year of 2008 for the DGET, the office electrician and the plumber trade. That it is humbly.
No, but have you given that? Because your email says I'm unable to log in. Thereafter, you have given this. Where is it? That you have actually submitted. Where is the endorsement or registered post receipt?
Running page 21, madam.
Running page 21. Please read what is written in running page 21.
Respected sir, that is information.
Yes, please read what is written there.
Respected sir, when I am taking the admission of the trade does not in our IT.
Yes.
Kindly solve the matter for the admission of the students.
No, just a minute. What kind of communication is this, madam? Annexure 4. Inviting reference to the subject, I am to say that physical verification conducted. Infrastructure and other facilities in your ITI has been found deficient. As per where is that report? Now keeping in view.
Your Lordship, what had happened is that we had not annexed those reports with this notice, Your Lordship. So that is why they had come that we had not known the deficiencies. But when they came with the show cause reply, at that point of time, we gave them reports, Your Lordship, as to the, that is why we extended the admission date. And the matter is subject to Your Lordship on that point itself. But all these verification took place because the Ministry of Tribal Affairs and Social Justice, they asked the Skill and Development Department to conduct a survey, verify, for the scholarship to ST students, Your Lordship, ST students. Now, we were the implementing agency, the state. So when we verified and on those verification reports itself, because at that point of time, they revised the guidelines saying that students, not only students will be included in the portal, but it should be the institutions which should be registered in the portal. For that, the institutional verification took place, Your Lordship. So once institutions have found deficit, around 47 institutions out of 458 or so, Your Lordship. Those 47 institutions were debarred from that portal, Your Lordship. It's that portal and Prerna portal of the state for scholarship. Those ideas, they came forward before, Your Lordship. Because when we had given them the show cause notice, admittedly, we had not given them the deficiency report because they were present when the verification took place. At that point of time, it was known to them, Your Lordship. So after that, we have given them, forward them the deficiency reports, Your Lordship. And the matter is, I mean, it's very unusual.
Matter is pending. Where?
Batch
is
of
there.
cases.
If I remember, you've given us a chart there stating the deficiencies,
Yes, Your Lordship.
right?
Yes.
You have a list of institutions with the list of deficiencies. Please give that number. Let us tag it along with that.
Yes.
So you must be knowing. You must be knowing the number.
Yes.
Please give.
Yes.
Let's matter along.
I'll give it him.
So that, if you give it, we'll know what is the next date and tag it.
Well, what happened, my lord? That inspection conducted by the SCST department for scholarship. So for affiliation is concerned, that is separate. So for scholarship is concerned, the scholarship team conducting the inspection and stop our admission. That is very fantastic. That is, they have no local
That
standard.
can happen. That can happen. They might have conducted the inspection for the purpose.
Only for stipend, my lord. Whether the students are available or not.
Therefore, they found that there was nothing. If they find in course of that verification, if there are so many deficiencies there, they have the duty to take a decision.
Yes, madam. They have not identified what deficiency, madam. Common deficiency. Because some of the IT, they have existed more until 2008, madam.
This is that batch? Batch?
Yes.
Along with.
OD number tap on date telephone.
Find it.
1919813 2024.
Reading station 19998.
In the middle counter to the at least in the counter, but deficiency is the common deficiency no? Because different IT have a different deficiency.
The state shall be at liberty to file counter affidavit.
Reached on that day.
So no date.
Not reached on that day. So,
Number tap number tap.
Give a date.
I will model.
Yes, 11.
Can this matter and all matter will
16.
2nd December.
9th. For 1 week they can't give the counter.
9th December.
Counter in the meanwhile.
Yes.
And tag of the matter?
Number put it in the mobile.
19987 of 2024.
Next matter that comes.
1011 already.
Huh?
1011, 1011.
I may pardon me, Lord. Item 41 million, item 41, I have received it 2 days back counter. I will finally rejoined.
So let the matter be taken up. So sometimes I feel bad when the courtroom is vacant. This is matter on 28th.
28 at 2 p.m.
Yes.
For admission, item number 29.
This case, you also directed me to file the copy of the rules, cadre rules. That has not been found. I asked for, I have not got it. Let it come next week.
Which are those rules?
29. Regarding pension, area pension, etc. Now the matter is objected by AG in granting pension because the RACB that has been given to them in 2013 at higher scale than 4,200, but actually due is 2,400. So while sending the pension to AG, AG objected to that. So that matter came a decision now under consideration. So Lawrence Signature disposed the matter, so far amount was paid that cannot be recovered. If that is recovered, that will be refunded. So far the fixation of the pension is concerned, as per rules that have been fixed. Fixed means the servitude that governs, that is the only point. And he has been asked to give option
that as per rules that it will fix, not as per the wrongly what the amount that will be paid.
Not as per the, as per the rules, not as per what?
My lord,
You are saying as per the rules, not.
because here scope of promotion is three stages. Those who are stagnation, they will be only eligible to get the RAC. Since she has avenue of promotion three stages, so he is not eligible, that is what I say. So the service rule is concerned that your lordship has to produce. I have asked them, they have not given.
Means the service rules are not available otherwise.
Other, only a scheme is that there, rules are not been framed, that's why an affidavit they have filed in March, that's it.
If there are no rules, then what rules will they give?
My lord,
If no rules have been framed, then what rules will they give you?
RSP scheme 2013.
That is not available anywhere.
Under that scheme, he will not be eligible to get.
But has been wrongly listed for admission, I think.
I think delay has been condoned, only that IA is fighting.
Our counter affidavit in WBC, there is a file we have annexed here at page 26, my lord.
With reasons.
But this has wrongly been listed for admission. It will come for hearing.
It is already admitted.
It is already admitted. The appeal has.
So finally, listed several times on the listed. Several times it is listed on this.
And I have not seen even a single case listed for hearing.
We have new section officers. They probably are not aware that matters can also be listed for hearing.
Yes. When the young lawyers may not be knowing.
It will never, case of pension, it will never reach pension.
Well, cases.
But it must be decided.
Case of pension. I retired in 2000. I got it in 2013 manage.
All right, it will be listed under appropriate headings. Let the system
Learn how to.
start. The present intercourt appeal has been wrongly been listed for admission. Since it was already admitted by an order of this court
10/8/2023.
dated 10/8/2023. So, what is this matter for hearing on 2 weeks?
Sir, yes.
2 weeks.
Yes, ma'am.
2 weeks. Monday to be taken up at 3:30.
Yes. That will be.
Item 30.
Your Lordship, in item 30, I'm appearing on behalf of Ms. Behura, the counsel for the petitioner. On the last occasion, Your Lordship had issued notice. We have not yet received the reply of respondent numbers 1 to 4. We have received a copy of the reply of respondent number 5.
Delay has been condoned. So, what is the con in admission matter? What is appeal? That is what.
Yes, Mr.
You're appearing for respondent 5?
Sir,
Yes,
just now we have given a copy to
Mr. Counsel, respondent 5 is present here.
Your Ladyship, we have received a copy of the respondent numbers 5 reply through email. 1 to 4, we have not received their counter.
It's a writ appeal, no counter is required.
Oh, your ladyship, then your ladyship may fix it for a hearing.
Hearing, right?
Oh, your lordship, I'm appearing on behalf of Miss Behura. She is on her legs in the Delhi High Court.
That is a different thing.
You are there?
Your ladyship, but the reply has to come from 1 to 4.
The counsel. Counter
Yes, your ladyship.
not necessary in a writ appeal.
Oh, your ladyship, the main counsel is Miss Behura. So, may like request your ladyship to fix it for a hearing date then.
Very difficult for us to convince you, Mr. Counsel.
Respondent 1 to 4 is the state of Orissa.
Yes.
The private party
Yes, your
is
ladyship.
present in person here, respondent 5. Yes.
Your ladyship, and moreover, the counter that has been filed by respondent number 5, that supports our case. They've clearly stated that we do not have any role in this and we could not have misappropriated the amount.
All right. Let us hear. Then you make your submissions, we'll hear you.
Your ladyship, the main counsel is Ms. Rajdeepa Behura. She'll have to make the submissions.
You are the Sarpanch.
Yes.
Naturally, they have appointed, so they will support us. You are ready? You filed a counter in this? In the writ appeal, you have filed a counter affidavit?
Sir.
Where is it? Counter affidavit again?
Right here.
Appellant को कौन हातरे हातरे देले? Appellant को counter affidavit टा? पोस्ट पठेले. अब इटी कोर्ट रे फाइल करले नि? The appellant, so you have copy on the appellant, not on the court.
What is wrong with the order?
Will argue, she's arguing the Delhi High Court.
Then let him remain in Delhi High Court.
Sir.
As requested on behalf of the appellant, list this matter on 1 week.
31.
In this case, I am appearing for some of the rest of the respondents, but I can concede to this, person may not record. I found that, in fact, notice was issued, directed to be issued by the signature by registered post. Requisites has been filed late, but notice has not been issued. And the ex parte order has been passed. I am the respondent, I am appearing with all the respondents. That is what I found also from record. I verified.
The other party is my lord. There are the other 4 writ petitions are pending. Previously, these writ petitions asking the same prayer for regularization. That those petitions are pending. This petition filed later, my lord.
So,
Say praying the same petition.
No. So the application cannot be disposed of if the other applications are pending.
And they have not disclosed the pending writ petition.
They are the petitioners there.
Yes.
Oh, I have tried.
I have given all the numbers, my lord.
I have to take
No,
instance.
are you sure?
Yes,
That the
I have
same
given the number, my
petitioners
lord.
had
He has
filed-
not disclosed that in the
Mr.
writ
Swami,
application.
Yes.
Are you sure that the same writ petitioners had filed other writ applications with the same prayer?
Yes, my lord. Let me kindly have a look
Yes.
to my appeal, page 18.
Appeal page.
For last paragraph, my lords,
No, your paragraph won't do.
23.
What will your paragraph do? What you are saying, we are listening to that. Any document to show the prayer that.
The petition numbers are there, my lords. I have given the repetition.
What do we do with the numbers? Unless the petitioners are the same, cause title is there, prayer is there.
That I see.
Petitioners are same, my lords, so that may stand. Let's may kindly call for those writ petitions, my lords.
It is your duty to give it to us. If you are, it is your stand.
Yeah.
You will not file the writ appeal. That is one of the grounds. So you should have given those annexures. We can call for.
Yes.
But
Let's make call for that. So the prayer can be, my lords.
means
That's
without
okay.
without seeing the prayer, you made your averments. Very strange.
No, I have seen, my lord. I have not brought it. I'll give.
Bring.
And the other thing is, my lords, the
You are appearing for the appellate.
appellant, my lord.
We are satisfied that the order was passed without service of this. Therefore, we can interfere with the order. We can demand the matter back to the license.
Well, additionally, could not have done the same thing. The result will be the same. The order will be set aside and remanded back. So even if we don't look at that other averment of yours, tolerate.
The rest of the respondents also I am appealed, my grandson is appealed.
The Punjab National Bank has to challenge. And order dated 22/4/2024. Passed by we learned single judge in WBC number 12819 of 2021, whereby the writ petition has been dismissed. Yeah, sorry, this petition has been allowed and has been disposed of with a direction to the bank to consider regularization of services of the petitioners and grant all consequential benefits as due and admissible to the respondents in accordance with law. So, when counsel appearing on behalf of the petitioner has submitted that the said order, impugn order has been passed without service of notice upon the appellant. So talk. Next. On Mr. Rautral and senior counsel appearing on behalf of the respondents has not been able to controvert the said stand taken on behalf of the appellant. So top. On perusal of the records of WPC number 12819 of 2021, we find substance in this submission so advanced on behalf of the appellant. So, accordingly, the impugned order rated so and so is set aside. The writ petition stands WPC number so and so. Consequently, WPC number so and so stands restored to its original file. So, the appellant shall be at liberty to file a counter affidavit in the said writ petition within 4 weeks from today. Stop. Let WPC number so and so be listed before appropriate bench according to roster. Yes.
For early disposal, may kindly, because appointments have been stopped due to this.
Oh, sorry. The order is not there.
32.
32.
My logic senior is on his legs.
1 week.
I think this passport prayer you have been making since last 2 weeks, I think.
Just last week, your lordship had sought for an adjournment. My learned senior is on his legs in the commercial court. He should be back in another half an hour or an hour.
Last 2 weeks. Yes, all right.
Item 33. Item 32.
No, kindly answer to tomorrow.
Tomorrow. Have you just a minute? You had mentioned this case for early listing. You had filed a mention slip.
Suddenly she fell ill.
You filed a mention slip.
Yes, ma'am. She fell ill today, ma'am.
Just a minute. You had filed a mention slip for urgent hearing.
That's why I'm telling it to tomorrow.
And I see all the mention slips in my chambers.
Yes.
And then I decide which matter, what are the matters which have to be listed. And in most of the cases which have been listed out of the adjournments are being sought. The case has been listed at the instance of London Council for the petitioner.
Suddenly she fell ill.
PL means paperless. It could be adjournment. Mention likha hota hai.
As requested on behalf of the petitioner, list this matter on 2 weeks. Yes.
Item 34.
Matter 3 weeks time may be granted for filing the counter affidavit.
3 weeks further.
The counter is necessary. Counter is
further time is allowed for the state to file counter affidavit. Yes.
Item 35.
Previous to blacklisting the petitioner's form melons. Meetings are complete in this case when counter is under everything is fine. I prepared a brief.
So where is the order?
Order your lordships will find my lords at annexure 15, my lords, page 88.
Where are those provisions?
Provisions, my lords, they have
OPWD
in their
code
counter affidavit. In the counter affidavit, annexed.
The total provision.
My lords.
They have annexed that OPWD relevant provision. All right.
Page 15 of our counter below. Page 15. One page. Clause 22.3.
Where is the no requirement of notice?
Requirement of notice, we had given the notice, notice, he has annexed. Both the so-called notice he has annexed. He has given the reply. We considered the reply. And thereafter this order was passed.
No, but in the order, there is no consideration. In the order which you have passed, there is no consideration.
Yes, that is the
only problem.
That is the only problem. I consider. The order doesn't reflect that so cause was given and reply was in, and considering that so cause reply, this order was that is lacking in the order.
What is the date of so-called notice?
The so-called notice, my lords, I'll just point out it. Your lordships will find that, my lords, at Annexure 6, page number 69. My lords, page number 70. Annexure 7, page number 70.
Annexure 6 is also a so cause.
6 is the prior so cause, but this is the final so cause against which I had filed my reply. And there is a
reply is dated?
The next annexure, my lords.
So cause is dated?
So cause is dated, my lords, 14/11/2022. And the reply, my reply is, my lords, within the stipulated time period, that is 29/11/2022, page number 72.
Annexure 7.
Annexure 8 is a reply, my lords.
And the order?
The order is, my lords, Annexure 50.
Date.
15, my lords, is 24/4/2024. This is the
24.
24. After 1.5 years, they have passed this order, my lords. In spite of 2 letters from the, my lords, the OP number 3 to unblock my portal registration, as well as to, my lords, not to take any action for blacklisting.
Just a
Immediately thereafter, this order has been passed.
That means they blocked your portal and then passed the order for blacklisting after 1.5 years.
I have already suffered for 2 years, my lords. On 15/12/2022, my portal was blocked. For 2 years, I have already suffered the punishment. And if your lordship sees just one letter,
You have a date chart or something,
I
why
have-
don't you give it?
even a date chart along with one second.
We are satisfied that your show cause has not been considered, so we can set it aside.
Because of the laxity on the part of the petitioner, the portal blocking came. And because of his negligence, he has, my lord, brought suffering to the state exchequer because of his own laxity.
Absolutely right. In fact, your submission is very strong that because he was lax, therefore this action has been taken.
And my lord,
You're right. So similar actions should be taken against the person who passed the order of blacklisting. Because he was also negligent.
Blacklisting is also a process, my lord, it takes.
No. The person who passed the order of blacklisting, he was also negligent. Because he did not consider his so-called reply. So when he was blacklisted for that, for negligence, then he should also be put under suspension and disciplinary action should be taken against him. Who is the officer who passed the order?
My lord, that was the chief engineer.
See, you cannot take this plea. While defending the order, you cannot take this plea that he was negligent, he did not discharge the duty, he did not discharge his obligation. Because you are not discharging your own obligation.
Delay in the matter, but process, my lord, that's a procedure, government procedure.
Procedure for issuing show cause notice. Show cause notice,
Because reply here.
procedure has not been followed. You have not considered the show cause.
All right. What was his reply?
His reply.
From your order.
Yes. His reply is at page 72.
So that reply is not there.
That is not reflected.
Joinder Singh Gill.
That is not reflected in the order. The only lacuna is that we have not reflected in our order regarding
reflected. There is no question of you don't apply your mind, then how can that be reflected in your order? The question, it's a simple case of non-application of mind. That's all. If you did not have, then you should not hold the post.
Yes, and the matter was considered. The plea which has been taken in the so cause, it was also considered, not in the order.
But subsequently, we have considered that these are not maintainable.
Subsequently, after rejecting his application, you have considered
No, 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 no.
subsequently.
Before blocking the portal, we had taken that stand
When
in
was
our
the portal?
cancellation of bid.
When was the portal blocked?
Portal was blocked, my lord. I'll give you the exact.
30/12/2022.
Yes. 15/12. No, the
Portal was
cancellation bid was
30/12/2022.
15/12. Annex 9.
Cancelled.
Cancellation of bid. The lame excuse.
It was submitted on 29/11. Portal has been blocked on 13/12. Even then, reason order as an action.
13/12, my lords, your lordships will get it at annexure number 15.
So we found it from your date
Later
that you
dates,
mentioned.
that document is at annexure 14.
Okay.
In fact, if your lordship sees annexure 14 is very crucial. Annexure 14, well, this is the letter just prior to this blacklisting. Annexure.
So their letter, your letter.
Their letter from the chief engineer, the OP number 3, my lords, writes to the OP number 1, not to my lords to unblock my portal registration, as well as my lords take steps not to my lords blacklist me, since the recommendation was made more than 1 year, 3 years, 1 year, 3 months ago. But since no action has been taken, so hence steps may not be taken for blacklist. But thereafter, within a month, this order has been passed.
Who is opposite party number 3?
Three Millers is the chief. 3 is Miller chief engineer, DPI roads.
Chief engineer, DPI roads, Odisha Bhubaneswar.
In the present writ application, the petitioner has put to challenge an order dated 24/4/2024 passed by the chief engineer, bracketed DPI, PPI and road, bracket road, Odisha, bracketed IC. Date लीजिए 24, whereby the petitioner has been blacklisted with immediate effect
April 2020.
Immediate effect in terms of the works department OM number so and so to orders the annexure 15 on the grounds of non-submission of a required initial security deposit and additional performance security and backing out for withdrawal of the agreement after receipt of LOA or letter of acceptance, bracketed LOA. Full stop. Before issuance of the said order dated 23/4/2024, the petitioner is a partnership firm registered under the Partnership Act and claims to be a super class contractor registered under what? Must be some department or
Registered under the The annexure 1 says PWD contractors minutes.
Registered. Under Public Works Department of the state government. So stop. After having heard learned counsel appearing on behalf of the petitioner and learned AGA representing the state of Odisha, we are of the opinion that this writ application deserves to be disposed of on a short point that the impugned order dated 24/4/2024 is unreasoned and does not reflect any application of mind in as much as it does not show any consideration of the so-called reply filed by the petitioner. Stop. Next, a so-called notice was issued to the petitioner on 26/2022 by the superintending engineer Pool Bunny bracketed R&B division Pool Bunny in relation to the tender for the work, quote, widening and strengthening of Gochapada Balanpada Malkuda road from 0/000 kilometer to 24/000 kilometer in the district of Kandamal under a state plan for the year 2021-22. Stop. From the said notice, it appears that the petitioner was asked to reply as to why, asked to suppose as to why the tender awarded in his favor not cancelled with a recommendation for blacklisting of his license. Stop. This was for the reason that in relation to the said tender, at the petitioner's request for submission of petitioner's request for allowing 15 days for submission of ISD and APSD was rejected on 7/6/2022. So stop. Despite that, the petitioner had requested 8 more days for the said purpose. Full stop. Apparently, mainly for the reason that despite issuance of letter of acceptance that after issuance of letter of acceptance and time given to the petitioner to complete the formalities of the agreement, comma, he failed to do so, comma, the said so-called notice was issued. So stop. The petitioner did submit his reply on 29/11/2022. The matter remained pending thereafter. First off, it is the petitioner's case that in the meanwhile, the petitioner's portal was blocked on 13/12/2022 by whom?
That's by minutes the state procurement cell.
By the state procurement cell. Thus, prohibiting the petitioner from participating in any tender process. Participating in any tender process. Preventing कर दो, prohibiting here. Nearly 1.5 years after nearly 1.5 years after the so-called notice was issued and the petitioner had filed his reply, comma, the impugned order came to be passed on 24/4/2024. Full stop. Next. A counter affidavit has been filed on behalf of the state. First off, there is no denial of the fact that the petitioner's reply submitted in response to the so-called notice was received by the competent authority. The said fact is disclosed also in the impugned order dated 24/4/2024. So stop. On plain reading of the impugned order, we find that there is absolutely no discussion as to what was the reply of the petitioner is in response to the so-called notice. First off, since in our considered opinion, the impugned order dated 24/4/2024 is patently unreasoned and a result of non-application of mind. First off, accordingly, the impugned order dated 24/4/2024 being unsustainable is hereby set aside. First off, the competent authority shall, however, be at liberty to pass an order afresh after due consideration of the petitioner's reply to the so-called notice filed on 29/11/2022. Stop. While taking any decision on while passing the order afresh, the opposite parties shall also keep in mind the petitioner's case that the petitioner's portal remained blocked logged even before passing of the order of blacklisting from 13/12/2022,
29/11.
13/12/2000.
You mean block from 29/11/2022?
No, no.
13/12/2022.
13/12/2022. Since 13/12/2022. Oh.
I think, after local notice was
Allowed, so that application is accordingly allowed with the observations. Observation as noted. Oh, this will come next week. We missed to see.
Hearing has concluded.
Yes, the hearing has concluded. We come next week for judgment for that.
Item 37.
Then this time is allowed for this matter on as requested on behalf of the state. List this state of Odisha list this matter on 2 weeks for filing counter affidavits.
Item 38.
Great Lords. The petitioner challenged the order passed by the Tahsildar in Minor Mineral Rule 2016. Against this order, appeal is lies. At appeal Miller, after in 2023, the minor mineral sources has transferred to the Department of Mines and Steel and Mines. So the order passed by the Tahsildar, appeal lies before the suppletor. But after transfer of the minor mineral sources, the appeal lies before the Deputy Director of Mines. But as the order passed by the Tahsildar, the Deputy Director of Mines does not consider my appeal. And the same thing happened to the suppletor. He has not considered that the already minor mineral sources transferred from our department will not entertain the appeal. That is my whole reason. We'll try count. Next.
counter.
On the board 46, appeal lies. Then if the order is passed by the Tahsildar, it is applicable for the sub-collector.
What is if the order is without jurisdiction?
That is the point.
Fine, one if the file also will become clear.
This was the point of the competence of Tahsildar. Two weeks further time is allowed for the estate to comply with the order dated 28/10/2024 by filing a counter affidavit.
Next week, Lords.
2 weeks.
39.
1 week.
1 week.
2 weeks.
All right, let it come
No further time will be granted because it is on this short point.
by way of last indulgence. Yes.
39.
9, 12 or something. Adjournment. Now adjournment. लिख दीजिए वो
36.
No, 39, I think both of them submitted. Mr. Ramesh Sahu had That he wants to file counter, if I remember correctly. Navaruku. No, Navaruku adjournment, I think. He said, I've taken consent, I want to file a counter. I'm on board. Probably he said he'll be here, keep on one for me, but he had made a mention. Petitioner counsel is not there, so most probably that must be the understanding. Madam, the applicant should be here. The party took time to file counter affidavit. Hot for time.
Someone check the time.
Yes. Also.
And requested on behalf of the petitioner this matter on 9/12.
Opposite parties.
Opposite party this matter on 9/12.
Yes, ma'am. Item 40.
What should we have served a copy of the rejoinder to opposite party 3 and 4?
Okay, so argue.
Your Lordship, the matter may be kept for any short date for hearing.
Yes, what is this about?
Well, I'm appearing for the university. I just received the counter just now. Sorry, the reason topic. So I'm not in a position to know. The matter is about the admission to the university in
Which
two
university?
PG courses.
Which university?
Barampur University.
Which course?
In PG courses.
No, in
Already-
PG course means he had already pursued one course.
Yes.
Wanted to do, is there any bar?
Yes.
Where?
As per the common prospectus was also there. In that common prospectus, you also kind of glance at page 65, which is also the impugned order here.
How can it be the impugned order prospectus? Which page?
66, man. In the Writ petition. This is also the impugned order.
And with the order.
Madam,
it is impugned.
This is impugned, and this was also inserted in the common prospectus.
Yes, so it is not the order, it is the prospectus.
Madam, one has it has been impugned in this Writ petition.
How strange.
And this order has been passed in pursuance to the proceedings of the Academic Council of the University and also the syndicate resolution. Your Lordship, and I have
Yes, that is all right. But how do you support this decision?
Madam?
How do you support this decision? Why should anybody be prevented from doing another PG course?
Because I am showing this, those who are pursuing for the second PG course, they are creating nuisance and all the nefarious activities in the university. It is,
So that is, taken to be granted that anybody doing second course is nefarious.
This university, even though Utkal University also has also made that resolution in the year 1965. And my humble assumption is that this is the opinion of the experts, and the experts in their proceedings of the Academic Council, so many 29 experts and others, they have made decision to maintain an academic atmosphere in the university. And I may be permitted to write a constitutional judgment
in the hospital. They may not.
So since the expert opinion have been
All
made.
right. So you have taken this decision by Rampur.
Madam.
Under which provision of law?
Because of the proceedings, only they have taken the decision. So also kindly have a glance at that.
No. See, you have taken a decision.
Madam.
You have taken a decision which is there at page 66.
Madam.
So where do you have this power? Whatever you do must be backed with some power, some statutory power, or something. Where is that?
My humble
Which
submission is that
jurisdiction you have
this
exercised?
improvement has been passed in pursuance to the proceedings of the Academic Council and the.
Where is that?
So whether
My-
whether academic council has such power, whether the academic council can take a decision, because it is a university, because there is academic council, because there is a vice chancellor, they can take any decision.
The Vice Chancellor has not taken this.
So whosoever, that is just by way of an example.
My lord. My lord.
So you have taken a decision.
My
This decision you have taken by applying which provision of law? Simple question.
Take instruction.
No,
Okay,
no,
section.
the answer is itself there. A few students take admission in another PG course with intention to create nuisance.
This is page 10 of my count.
Yes, that I am reading.
May-
So
may I
if
go?
few students do that, all students will be barred.
The Academic Council explicitly.
Mr. I am referring to your resolution of dated 2021 at page 10 of your counter. Yes, last paragraph. Yes.
The Academic Council expects its consent.
Arising out of discussion, the academic, yes, that a few students. Yes.
And that was also confirmed in the syndicate resolution.
No, they have just without any reason.
So
they have confirmed.
therefore, if the academic council is of the view that the students coming from particular area create disturbance in the university, can the academic council take a decision that persons from that area should not be allowed to pursue their courses?
My submission is that it is not the allowed area. It is the.
This is just an example.
This is just an example, whether you can take any decision because of this, whether you have the competence, whether you have the power.
For smooth conduct of the university.
The smooth conduct of the university, even that can be done.
What they are doing that after in the second PG, after taking admission, they are instigating the students to make unruly behavior. They are taking hostel seat, and in that hostel seat, they are creating disturbances.
You are answering your own question. I mean,
And you know what is emerging from what you are submitting? That your vice chancellor or the university administration is thoroughly incompetent to handle this situation.
The other universities have also taken.
Other universities.
they are not here. Other universities are not here.
I have
You have to ask them also.
Utkal University.
Maybe.
Utkal University has also taken the same.
Just a minute. The petitioner in the present writ application has put to challenge the decision of Bahram University, Bhanja,
Bhanjanagar.
Bihar,
Bihar. Sorry, Bhanja, sorry.
Ganjam. Thereby, it has been decided that a student who has completed post-graduation course in any subject from Bahrampur University shall not be allowed to take admission in any other post-graduation course of Bahrampur University from the academic session 2023-24 onwards. Full stop. Plain reading of the said decision, it can be inferred on plain reading of the said decision that though the students of other university after completion of a post-graduation course can pursue another post-graduation course in Bahrampur University, but those who have completed such post-graduation course from Bahrampur University cannot pursue another post-graduation course in Bahrampur University. Stop. Next, let an affidavit be filed on behalf of the university stating the source of power in exercise of which source of statutory power in exercise of which the said decision has been taken. So the court will consider the legality of the said notice on other grounds after the said affidavit is filed. So stop place this matter on 2 weeks. In the meanwhile, the affidavit must be filed. Yes.
Item 41.
Hello. In this case, I have received a counter of 2 days back. I will file a rejoinder and take some instruction from the petitioner. The
Counsel
counter
appearing on behalf of the petitioner seeks adjournment to file a joinder to the counter affidavit, a copy of which he has received recently.
Yes.
So as requested, list this matter on 2 weeks. 2 weeks.
Yes.
Item 43.
Adam, your name, you're giving that, your name, what is it?
Again,
Item 43, your lordship, on last occasion, order dated 11/11/2024, directed to the additional government advocate to file the counter bills. That's my take on the next week.
As requested on behalf of the state of Odisha, list this matter on 1 week further time is allowed to file counter affidavit. List this matter on 1 week.
44.
44, your lordship, I am appearing on behalf of the opposite party number 2. I received the PWC, your lordship, I call it next week, I'll file my counter.
What is PWC?
Parawise comments, your lordship. My lords.
Yes. How much time?
Next week I am paying for.
Counsel appearing on behalf of the, what is this?
Matter regarding the, we have challenged the entire.
No, this is item number 44.
Your lordship.
You are appearing for?
Opposite party number 2, your lordship.
Who is opposite party number
The
2?
executive officer, NSC Bhanjanagar.
NSC.
Your lordship.
Area council.
Counsel appearing on behalf of the notified area council, Bhanjanagar, seeks adjournment to file counter affidavit. List this case on 2 weeks.
I was praying for next week, your lordship, my grant.
One week. Time to
Praying for subject minor, because my bid has been selected as L1 minor. Despite that, on the ground that no power of attorney I have furnished, for that reason, the bid has been cancelled by them. Only minor quantity is involved.
1 week.
File the counter before that.
Your lordship.
Yes. But we are also given.
This case 1 week. Yes.
Item 46.
Great.
This is the blacklisting matter, Miller. Take 1 week and file out.
Yes. List this matter on 1 week. Let in the meanwhile, the counter affidavit be filed on behalf of the state of Odisha.
Item 47.
Item 45 election.
45.
45 we have disposed it of in your absence. Is that nursing matter?
Yes.
Nursing.
Yes.
So your prayer has been allowed.
You were not there, but similar matters were being taken up, so your application has also been discussed.
Similar matter. You have got the relief.
Only thing your name, if you say, will mention it. What is your name? Okay.
Yes.
47.
Yeah. The Lordship may take up 12717 of 24 first. Here,
127, just a minute. This is RAPS
Yes.
Infratech.
That's
For both the petitions are the same petitioner. One is where he has been, he has qualified and his case has already been recommended, but work order is not being issued. And the second is a case where he has been technically qualified because of pendency of cases.
He has been technically qualified because of pendency
Technically
of cases.
disqualified.
Okay.
That is the first matter. I'm coming to the older matter first.
Is it covered with the endorsement or not?
This is what he has submitted and.
My experience begins, let's see, kindly have a glance to order number 1 million.
Yes, that we have seen.
That is the case, Procedural Technologies case. Let's see, pass the order. My humble instruction is that, against that order, hearing in SLP is going on.
Hearing is going on.
Going
all right. Then
that is with regard to this first matter, whether pendency of a proceeding would disqualify a technical grade. That's the second matter, but the first matter doesn't have anything to do with that. The second matter doesn't have anything to do with that.
No, this is WPC 25273.
Yes, my lord. That, my lords, their plea now is that against that Rose matter judgment which your lordships have delivered, that is not the solitary judgment on that point. The other case was also, but anyway, your lordship had passed the judgment that they have assailed in the Supreme Court. There is no interim order there. It is just pending there.
No, but
they say it is pending. Let us respect.
No, it says the hearing is going on.
No hearing is going on. They have been taking time. That is my information. That is my information. That is as far as your lordship may take up the second matter. That has got nothing to do with this matter. Second matter, your lordship can take.
So the order was passed. All right, let us see second matter. Second matter is WPC.
WPC number 12717 of 24.
Yes.
Your lord, they have filed a counter affidavit. Counter affidavit, page 8, your lordship. Your lordship may take from page 6.
No, this is blacklisting.
Yes, madam. Blacklisting. They have.
Why both the cases have been tagged?
Because, my lords, what the petitioner endeavors is seeking to see put forth before your lordship is the utter discrimination that he is being subjected to.
No, see, the first case is entirely different.
They stand on different footing, but both relate to the same department. And my lord, what is happening is this, my lord. My lord, to stay as a contractor of a particular grade, a person is required to have the particular turnover per annum. If he does not have turnover of...
So how is the second item connected with the first one?
Exactly, my lord. The connection is this, my lord. The attempt of this department is to somehow or other prevent the petitioner from executing any work.
No, but first must be the policy decision. That
No,
doesn't apply to you.
there is no policy decision, my lords. But it is basically based on the whims and caprices of a particular officer.
All right. So in
That
the first,
also-
just a minute. In the first case, you have been denied only on the ground of pendency of some case.
Yes, my lord.
Not
And
applying any.
this is the other case. This is the pendency. This is the other case which is pending. On the ground of
How Rose Mata will apply? Rose Mata is policy.
Policy.
Policy was struck down.
Absolutely, my lord. So that is the ground on
And
which
this is indeed a decision taken in an individual case.
Yes, my lord.
In your case.
Yes, my lord. It was taken in my case, and which is opposed to public policy, which is opposed to judgments delivered by the Supreme Court as well as your lordships. They want to have another round of fight, they can have it in the Supreme Court. There is no stay order operating. Your lordship may kindly see this, the defense which they have taken in the second matter.
Yes, where is the order in the second matter?
Second matter, second matter order, yes, but the
Blacklisting.
Blacklisting order.
Where is the order?
Blacklisting order was quashed by this honorable court.
So what is the second case about?
The second case is, despite quashing of the blacklisting case, they thereafter opened my portal. I participated. I have qualified. On all the technical bid, financial bid, my bid has been found to be the best bid. My case has been recommended for award of work order. The work order is not being issued for reasons which are there at page 8 of the counter affidavit. Page 8, the SLP which they are referring to is the SLP against the order of blacklisting. It is this ground alone, my lords, which has held them back from issuing the work order, in my view.
Which paragraph?
Paragraphs, it begins at paragraph page 6, my lords. It begins from page 4. Para 14, your lordship may see that in reply to arguments made in para 9, 10, 11 of the writ petition, somebody submitted petitioner participated in the impugned tender, wherein after opening of financial bid, the necessary approval was submitted to the state government for necessary approval. While the matter stood thus, on 14/3/24, meeting was held in the conference hall of the Works Department, presided by the Principal Secretary of Works Department and officers. At the said meeting, it was inter alia decided. The minutes of the meeting are there, and the conclusions are at page 8. It may be noted that the aforesaid SLP is pending before the Honorable Apex Court, wherein the Honorable Court granted time to the present petitioner to file counter affidavit. As the matter is pending in the Honorable Apex Court, the committee unanimously decided to wait for further development. From the aforesaid, it is clear that till today, the committee has not approved the recommendation of the chief engineer in favor of the petitioner number 1 company. As the recommendation has not been approved by the tender committee of the state government, hence no right has accrued in favor of the petitioner.
Right. So valid. Wait, what right do you have?
The question is here, my lords, a right. I have qualified to get that right.
No, you have qualified to get that right, and the recommendation, unless the recommendation is approved by the tender.
The recommendation, my lords, firstly, the tender document does not provide for such an approval.
No.
It does not. It does not.
There is OPD.
No, it is not there. My lords, I have scanned the tender document from end to end. There is no provision in the tender.
Code, OPWD code, it is there.
The state government's approval is not necessary, my lord.
Yes, it is.
It is the chief engineer.
What is the amount? What is the amount of work?
The amount is. Tender document. Thirty-four. 34 crores.
34?
34 crores. Making of a road, Bharat.
We will see the.
Nanda Infratech.
We have referred to either beyond 70 crores or 10 crores.
Manoj, the point here is, Manoj, when I
Let us see
qualify.
the OP, because we have not seen that. We just let us examine.
Now, the other day,
This I was checking the rules matter. There's the impugn order has been stayed. Mr. Mukherjee, why do you say it has not been stayed? Or is that? Yes.
No, in our case, nothing, no stay
Not
order.
no case, that rose matter, which is pending. We said it is pending for. Rose matter, the judgment has been stayed.
Yes, but
The last
And Rosemata has no application in your case.
only in the first matter, I had referred to that, in the first writ petition. It has got no application in the second writ.
Yes, yes.
In the second writ petition, I had referred to some judgments of the Supreme Court.
I am sorry.
That has probably not been uploaded. That has been referred, not been uploaded. The last order is just check the number.
That's probably the progress.
And then you check.
Do you remember the clause in the court?
So probably that single bid, there is no. First time, if it is a single bid,
Then
it has to be cancelled. If it's second time, then probably they will take permission.
Chapter 9, Rule 23.
Chapter 9, Rule 23, OPW.
29.
Chapter
9. Rule 29.
Clause 29.
It is amended in 2015.
15.
Yeah, 6.3.15. Yes, please come. This is not one.
Sorry, Manoj. Yes, the code.
Yes.
But on the last occasion, if you're not, I'll just reiterate what I had submitted when the matter was last heard by your lordship. I had said that even the state government cannot sit over it. They are duty bound, and the court can, when they see that, yes, they are sitting over something which they ought not to. A writ of mandamus can be issued. And for that, I had relied upon one judgment. That is, I had given that copy. That's in the case of Union of India versus Bharat Forge Limited. May I read out certain portions? This is AIR 1922, Supreme Court, page 3821. Para 15, Manoj.
Yeah, 19.
2022, Supreme Court, page 3821. I had given copies of that judgment, must be there.
Name of the party?
Name is Union of India versus Bharat Forge Limited.
I think so, yes. Can I take it?
This para 15.
It is not there. Okay, you have given. Yes, what is there in the judgment?
Para 15, my lord. May I read out? The learned ASG contended that the High Court erred in issuing the direction, which is in the nature of a writ of mandamus. It is this case that a writ of mandamus would lie only when a state imposes a duty and there is failure in discharge of duty. We would think that this is not a matter which is res integral. As early as in Comptroller versus Auditor General of India, Gyan Prakash, New Delhi, a bench of 3 learned judges of this court had this to say. The first contention urged by the learned counsel for the appellants was that the division bench of the High Court could not issue a writ of mandamus to direct a public authority to exercise its discretion in a particular manner. There is a basic fallacy underlying this submission, both with respect to the order of the division bench and the purpose and scope of the writ of mandamus. The High Court has not issued a writ of mandamus. The writ of mandamus was the relief prayed for by the respondent in the writ petition. What the division bench did was to issue a direction to the appellant in the exercise of jurisdiction under Article 226 of the Constitution. Under Article 226 of the Constitution, every High Court has the power to issue to any person or authority, including in appropriate authority, any government throughout the territories in relation to which it exercises jurisdiction, directions, orders or writs, including writ in the nature of habeas corpus, mandamus, quo warranto, and certiorari, or any of them for the enforcement of the fundamental rights conferred by Part 3 of the Constitution, or for any other purpose. In Dwarkanath versus IPO, reference to also, this court pointed out that Article 226 is designed couched in a wide language in order not to confine the powers conferred by it only to the power to issue prerogative writs as understood in England. Such wide language being used to enable the High Court to reach injustice wherever it is found and to mold the rulings to meet the peculiar and complicated requirements of the country. Thereafter, in AIR 1975, they quoted, this court held that the powers of the court in England, as regards the control which the judiciary has over the executive, indicate the minimum limit to which the courts in the country would be prepared to go in considering the validity of orders passed by the government or its officers. Thus, there is no doubt that the High Courts in India exercising their jurisdiction under Article 226 have the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statutory rule or a public policy decision of the government, or has exercised such discretion mala fide or on irrelevant considerations, or by ignoring the relevant considerations and materials, or in such a manner as to frustrate the object of conferring such discretion or policy for implementing such with such discretion has been conferred. In all such cases, and in any other fit and proper case, a High Court can, in exercise of its jurisdiction under Article 226, issue a writ of mandamus or a writ in the nature of mandamus or pass orders and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the government or a public authority, and in the proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order to give directions which the government or the public authority should have passed or given had it properly and lawfully exercised its jurisdiction. It goes on, my lords. There are various other judgments to which they have referred.
There is no the principle. There cannot be any controversy about that.
So yes,
there are two aspects.
Yes.
One, it is difficult for you to convince us that because of that decision, the court should direct them to award you the work. That cannot be done.
No,
they have a duty of course to take a decision on the recommendation. That is in public interest also. Why the matter should remain pending without any reason. But till that recommendation, till a decision is taken in your favor at that level, you don't have any right.
True, my lord, and that is exactly where, my lords, I'm beseeching the courts to step in. Because a right is there for me. I have
Why
worked
are
for
you
that
not
right. I have
taking
come
a
up to that level.
Why are you not taking a decision? See, like you say that there was an order of blacklisting. That order of blacklisting is no more. All right. Despite the fact that the SLP is pending. So you cannot say that because you pass the order of blacklisting, that the petitioner shall remain blacklisted despite the order having been set aside because the matter is pending consideration. So you cannot rely on that order of blacklisting, one. And two, you have to take a decision accordingly. You cannot use that order of blacklisting for taking in decision. You will have to take a decision on the recommendation made by the committee or the chief engineer, whoever.
My lord, as your lordship has rightly pointed out, that despite a writ court having quashed the order of blacklisting, I am still being subjected to the same.
Oh, okay, no, this is
I am still being subjected to the same.
very unreasonable.
Nice. That's in the on this matter, one chapter, I think instructions to the department.
Your lordship may see your lordship had made an order on order number 93924. Your lordship may kindly see that order.
No, that was referring to Rose Vata or something.
No. In this case, your lordship passed an order on the 3rd of September 2024. Order number 9. They were called upon to inform your lordship.
So thereafter, no affidavit has been filed. You have not filed any affidavit after this 3/9/2020.
They have not. We have filed an affidavit saying that they are basically taking a pick and choose policy. They have, in fact, after the blacklisting order, they have issued another work order in my favor after the blacklisting order was passed. How can they take a defense to that effect in the present case, my lords?
Same authority or
Same
different?
authority. Annexure A, my lords, at flag D, the affidavit your lordship may see. Now, my lords, as I pointed out at the very inception, my lords, what this is having a devastating effect on me as with my source of livelihood.
But you're saying they have issued a work order in your favor.
They issued a work order, but that my lords, is a small matter because it does not help my turnover in any manner. It does not help my turnover because what happens is at the end of the year, if I don't
So the
have
one which matters, they are not taking a decision.
and they cannot, this is only to show to your lordship that they cannot, in one case, say that we have filed an SLP, hence we will not give a work order, at the same time issue a work order in another tender. This is utterly discriminatory.
We file a period, your lordship can be valid, right?
So you are arguing the second matter. Second matter, there is an order on
Stay order.
5/8/2024,
Petitioner in the present writ application
subject to payment of cost.
is seeking direction to the opposite parties, number 1 and 2, to issue work order in favor of the petitioners in relation to the work of port improvement such as widening and strengthening of Bhavani Patna Gunnopur Kasipur Road bracketed SH44 from 2/500 to 13/095 in the district of Kalahandi under the state plan. This is correct?
Yes.
Unquote. Next, a counter affidavit has been filed on behalf of the opposite parties stating that admitting therein that the petitioner had participated in the tender process for the said work and the petitioner was found to be lowest bidder and the petitioner has been found to be lowest bidder after opening of the financial bid. So stop. It is however the stand of the opposite parties that that necessary approval by the state government is required of the decision of the technical committee on the decision of the technical committee. So stop. Since no approval has been granted in favor of the petitioner nor any work order has been issued in its favor, no right has accrued in favor of the petitioners. Stop. There is no averment, however, as to why no decision has been taken at the level of the state government based on the recommendation made by the tender committee. By the tender committee. So stop. Despite opportunity granted to the state to file an affidavit by order dated 3/9/2024, no affidavit has been filed. So by way of indulgence, last indulgence, 1 week further time is allowed to file additional affidavit stating as to why no decision has been taken on the recommendation made by the tender committee by the state government. 1 week.
Let me fix it.
Next. Next.
Certified which will not seem disposed of, but blacklisting matter. Let the authority decide the matter within a stipulated time. That was
Why are you making this submission? They should not let them not decide. At least there is no order against you. So you will prescribe the time that it should be done.
Portal is blocked.
No, portal is blocked. Yes.
Thereafter blacklisting.
No.
Yes, what they do is
consequences of washing off the order of blacklisting shall follow. That's all. Now it's clear. Now the blacklisting order has been set aside. So consequence, it should not happen.